Good afternoon, everyone. My name is Derek Davis. Welcome to the House Economic Matters Committee. We have 4 bills before us today. The first will be House Bill 340 by Delegate Pena-Melnick. The second bill will be House Bill 218 by Delegate Love. The third bill will be House Bill 148, Delegate Carey, and closing us out with House Bill 84, Delegate Feldmark. Delegate Pena-Melnick, I know you have a lot to do, so without further ado, please get us started.
Thank you so much, Mr. Chairman. Good afternoon, Mr. Chairman and Vice Chairwoman Dumais and members of the Economic Committees. I'm pleased to present to you House Bill 340 as amended. So we have requested amendments to it. We work with the stakeholders and they're in support. Proponents of a cashless economy cite the efficiency of non-cash payment methods in processing transactions. Merchants who adopt a cashless business model choose to abandon vital customer groups. This trend creates barriers for our most vulnerable constituents. Some of our constituents elect not to use credit or debit cards for routine transactions. These are often individuals who have been victims of identity theft, which is a rapidly escalating problem for our state and for our nation. Simply applying for a credit card is not possible for some. Many lack the credit history. Many are unemployed. Many are behind on their bills. Race-specific data also reveals inequities present in banking practices designed to deny access to services to Black Americans and other minority groups. 33% of Black households are unbanked, compared to only 11% white households. This issue is not the result of random phenomena. It is a deeply rooted in structural racism that has systematically governed banking practices to prevent Black Americans and other minorities from wealth building and other economic advantages that come with banking access. Mandating non-cash payments systematically discriminate against low-income and Black communities unable to open a bank account or apply for credit card. With the passage of House Bill 340, brick and mortar merchants will be prohibited from denying services or charging additional fee to customers who wish to make an in-person cash payment. The bill has been amended after discussion with stakeholders. Exceptions will be granted for parking lots, businesses that do not fall under the classification of a brick and mortar, and for transactions for rental of merchandise or accommodations for which posting of collateral or security is typically required. Additionally, merchants will be issued a warning for their first violation. We worked on this compromised because we don't want to punish. We just want to make sure that people have access to buying their products with cash if they want to, or credit card. Any subsequent violation will be subject to enforcement and penalty provisions. Simply put, people rely on simple transactions to power their everyday lives. In the middle of an unprecedented global pandemic and devastating economic crisis, we cannot, in good conscience, allow a practice that denies people diapers, disinfectant, and other necessities simply because a business does not accept cash as a form of payment or only accepts a credit card. Thank you for allowing me to present to you House Bill 340, and I respectfully request a favorable report. Thank you so much.
Thank you, Delegate Pena-Melnick. I actually, the bill intrigued me when I first read it because I've noticed that as well. And, you know, when you look on a dollar bill, it says it's legal tender for all debts, public and private. So you know, stood out to me when everybody was now just cash payments. So I'm glad for me personally, I know this isn't a question, but I definitely appreciate the bill because it was something that I had been thinking more and more about during the interim. So anyway,
thank you.
Are there any questions of the sponsor? I don't see any. If I'm missing anybody, please let me know. If not, Delegate Pena-Melnick, I'll go to your panel. The first being Meryl Chertoff.
Thank you so much.
All righty. Are you with us, Ms. Chertoff? If you're muted, unmute. All right, let's try Crystal Wright. Ms. Wright, are you with us? All right, I'm batting over 2 here. Let me try Marceline White. Ms. White, are you with us? All right, let's see if I can get the hat trick. Kaylee Locklear?
Present.
There you go. I was going to find somebody.
And Crystal just signed in, Mr. Chairman.
Okay.
Okay.
Mr. Chairman, honorable members of the Economic Matters Committee, Kaylee Locklear. For the record, it's really great to see all of you. Happy New Year. And I'd really like to begin by just thanking the sponsor and her team for working with us on this legislation. She's been very open to creating a couple of necessary amendments that I'll speak to, she's touched on as well. We understand how important this is for individuals who need to use cash due to a variety of reasons that she's already outlined. I don't think, Delegate, we actually have the amendments because I was on the phone with the amendments office earlier today, just clarifying a couple of things, but she already outlined the bill will not be applicable to existing parking garages or lots. Otherwise, we'd have to replace infrastructure that doesn't accept cash currently. And then we have an amendment coming in to address kiosks. So specifically in malls, typically, kiosks do not accept cash because they are so open, and there have been concerns there from them. That is a part of the amendments that'll be coming in, as well as, and I'm sure you all have seen them, they're in airports, they're in some stores now, but there are actually kind of store vending machines that do not accept cash. And one of the reasons is a lot of those items in those vending machines tends to be pretty high priced. So that will be a part of the amendments, as well as the rental of merchandise or
everybody, hold on, Kaylee. Please mute yourselves if you're not speaking.
Do not accept cash. And one of the reasons is a lot of those items.
Amy, Sean, I need you guys to mute yourselves.
So that will be a part of the amendment, as well as the rental.
Mr. Looney.
Rental of merchandise.
I think that's playback from Kaylee, Mr. Chairman.
I don't have anything on except for this.
These your admin can eliminate them.
All right, here we go. I'm sorry, Kaylee.
No, it's fine. So the other amendments coming in have to do with transactions for the rental of merchandise or accommodations for which posting of collateral or security is typically required. So specifically rental cars, hotels, and then there are actually equipment rentals as well for heavy duty machinery that require some type of security collateral as well. And then finally, and the sponsor touched on it, we also need something in there, and we talk about this in committee a lot. You all have enacted this in various portions of the code, some sort of written warning. We always worry about our smallest businesses who, despite our best efforts, may not be aware of this, and or somebody opens a new business and they're not aware of it. So before they're subject to an unfair and deceptive trade practice, they would be issued one warning prior to that. So with those comments, we urge a favorable report, and I thank you for your time.
Thank you. Double back now. I think we're ready. Crystal Wright. If you're there, Crystal, we need you to unmute. All right, Marceline White.
Good afternoon, Chair, members of the committee. For the record, Marceline White with the Maryland Consumer Rights Coalition. here in strong support of HB 340. And I want to make a couple points about why this bill is so important. As you know, this bill essentially says that you cannot prohibit the use of cash as legal tender for retail goods and services. And the reasons we feel this is important is because a cashless economy is not an inclusive economy. And what I mean by that is that 39% of Maryland families are struggling to make ends meet today. And that's from the 2020 Alice report. And to obtain a credit or debit card, consumers must have an ID, they must have a history of financial transactions or a utility bill. This could discriminate against undocumented individuals in our state, against unbanked and underbanked individuals, and 21% of Maryland households are un or underbanked. Last week, we talked about looking at public banking and looking at access to banking and banking deserts. And for individuals predominantly in communities of color who live in these banking deserts, it may also be hard for them to get access to debit cards to use for purchasing. Also, debit cards are costly for Maryland families and those living paycheck to paycheck. Many debit cards charge fees to reload the cards. Many charge fees if you don't use the cards enough, inactivity fees. And some will stop working altogether. They expire. So they are costly forms as opposed to cash for low-income families to use. It's also costly for many small businesses because small businesses are charged a swipe fee from the credit card companies when someone purchases a good from that store. So it also hurts small businesses. And finally, using cash protects individuals from hacking. I know this committee has talked many times about the problems we have when an account is hacked. We've seen Equifax, Target, and others who've had major data breaches. And I know this committee is looking at those issues again. Using cash protects people from those data breaches. So we believe that it's inclusive, it does not discriminate, and it gives people choice, which is one of the things we do in this marketplace. So for all of these reasons, we ask for a favorable report from House Bill 340. Thank you.
Thank you. Any questions of Ms. White?
I'm here. I'm off mute now.
Let me stick with Ms. White first, okay? Any questions of Ms. White? I don't see any, so thank you very much.
Thank you.
Are you Crystal Wright?
Yes, Delegate Davis and the chair of the committee. Thank you. I apologize for the technical difficulties there. And I'm happy.
It happens.
Yeah, I'm happy in this age. So apologies to you and Delegate Kathleen Dumas. And I just want to thank the members of the committee for allowing Cardtronics to offer testimony in support of Delegate Pina Melnick's bill. It's very important to us. Cardtronics, as a point of context, is the largest independent owner and operator of ATMs in the world. The majority of our ATMs are in the United States of America. Cardtronics is based in Houston, but every day in the communities we serve, we want to ensure that consumers can access cash, whether they're receiving it on their stimulus benefit prepaid cards or using a traditional credit or debit card. But more importantly, what we know is that there's a significant number of Americans in this country, as the delegate mentioned in her opening statement, Delegate Pina Melnick mentioned, who don't have access to any traditional banking services. They may be immigrants, undocumented workers, they may be elderly on fixed income, unbanked and underbanked, and they tend to be people of color. So when you have a rise in retailers wanting to shut certain individuals out of the marketplace, it's really shades of segregation that my parents fought against. It's saying that we want to serve a certain type of customer. So what Cardtronics has done over the course of the last 3 years is we have supported every municipality and state that has stepped up to the plate and wanted to protect consumer payment choice. There have been 27 active bills. Of those 27 bills, we have about 5 that have become law. Those include the District of Columbia recently. They also include New Jersey, New York City, Philadelphia, Rhode Island, and San Francisco. You have also had the United States Congress act in a bipartisan fashion to introduce HR 2650. Representative Donald Payne and Representative Chris Smith introduced that bill at the federal level. Last year, it gained huge bipartisan support. We understand from Representative Payne, he plans to reintroduce the bill and engage President Biden to support this very important issue of access and ensuring that consumers can pay with cash at brick and mortar for brick and mortar purchases. And in the United States Senate, we had a bipartisan bill introduced by Senators Robert Menendez and Senator Kevin Cramer. And finally, I will just remind everyone that demand for cash has never been stronger. We know that currency in circulation has topped over $2 trillion. And during the pandemic, we saw a surge in people accessing cash because they were worried about whether or not payment systems would be reliable. And you also, as I mentioned, you had millions of Americans receiving stimulus payments on prepaid cards. But even Americans who received stimulus in their banking accounts, they went to ATMs across the country and they pulled out cash because cash in times of economic decline and also states of emergency, everybody wants to have cash on hand. And finally, we know that cash is private and secure. And some Americans just want to use cash because they don't want big technology payment platforms tracking their every move. They want to control who sees, what they purchase, when they purchase, and the ability to be private in those personal transactions. So we are in strong support for favorable consideration of HB 340. And we also, I'd like to finally say that cash is also very safe to use. I know there's been a lot of misinformation during the pandemic that's been disseminated, but we have global central banks, as well as many health organizations worldwide, including the CDC, that have been on record saying that cash is a safe payment, and there's not been a single case of coronavirus transmitted through currency.
Any questions? Anybody?
Mr. Chair, Delegate Pippi.
Delegate Pippi.
Thank you, Mr. Chair. So Delegate, good to see you, my friend. I just had a question. I mean, ironically, listening to the previous testimony here, a lot of us don't have co-sponsors on our bills. We were told at the beginning of session that the reason for that is that they didn't want these paper bluebacks being passed between us. Obviously, we're in a global pandemic. That's probably why the sponsor here is the lone sponsor on our bill. I'm sure she could get a lot of folks to support her. But I'm just wondering, and I know that this bill wouldn't kick in until October, hopefully at the end of this pandemic. But I mean, I would imagine there are some benefits to not accepting cash. I know that, I just saw a commercial last night for Squarespace, and a lot of these startup businesses, they don't use cash at all. They just use a Squarespace payment acceptor. So, I mean, is there a downside to prohibiting? I mean, I looked at the 1964 law. I guess there was a question about whether a business retail establishment had to accept a certain currency. And there's some ambiguity there as to whether they actually have to accept cash. So I'm just wondering, I mean, are we going to cause any issues with forcing the business to maybe step outside of their specific business model? Is there a downside to it? I mean, obviously there's some concerns relating to passing dollar bills between individuals during the pandemic. I mean, I'm sure that's why we're not allowed to co-sponsor bills. But if maybe the last speaker could address that just briefly, and I understand the merits of the bill, obviously, but.
Yes, I'm happy to, Delegate Pippi. I'm happy to answer your questions on that. Let me address the one about the 1964, I think it was 64 or 67 Coinage Act on the federal level. Treasury interpreted that act as giving businesses the right to formulate their own payment acceptance policies in the absence of a federal, local, or state law prohibiting the practice. So subsequent to that, that's why you saw in 1978, Massachusetts became the first state in the union to pass a Consumer Payment Choice Act, law rather, that it's just one sentence. It says that if you're operating your business in Massachusetts, you have to accept cash only for brick and mortar purchases. And so there is no federal law. So we're not going to, that's why the states have acted. That's why the District of Columbia was the latest state to act. And you had, prior to the District of Columbia, the mayor signed the Consumer Payment Choice Act into law a few weeks ago in January. I believe it was the 13th. Cardtronics testified and worked actively and assiduously in support of that bill, that the bill and the law being enacted. And then prior to that, you had New York City, you had the list of states and other cities that I ticked off to you. So it is a concern. Otherwise, I don't think we'd see 27 municipalities and states acting. With respect to COVID and transmission of the coronavirus via currency, that has nothing to do with misinformation is being spread. Why certain grocery stores and other retailers don't want to accept cash. I'm sure you've been following the backlash they've received also with the coin shortage. They literally have been shortchanging the very people who can't afford it the most. So I'm happy to share with you post the hearing. I have 3 pages of independent data, including from the CDC, who revised their data in, I think it was April or May of last year. And they said that from their revised research, that the touching surfaces or objects is not the primary transmission of coronavirus. They said that the primary way that folks get coronavirus is close contact within 6 feet, coughing, sneezing. That's how the virus is spread. And we also know who actually has come out with similar guidance, as well as the Centers for Disease Control. And then we have a study that was done by the Bank of International Settlements that said the same thing. It was an April 2020 report that I can share with you, and that to date, there have been no known cases of COVID-19 transmission via banknotes or coins. So that's just not happening. And I think that you have special interest groups that are spreading that information because, as you point out, Delegate, there are certain individuals who benefit when they spread misinformation to migrate those away from cash. And let's not forget, there was also a great, and I can share all this with you. The Wall Street Journal did a study. It would probably be in the late summer of last year, fall, where you had a lot of small businesses complaining about the charges associated with accepting credit cards and mobile payments, to the tune of, I think an average business owner pays about $100,000 in credit card and debit fees every year. So I have all that information that I can share with you, but there is a huge cost to small businesses and medium and, other businesses alike. So I'm happy to share all that information that we've collected to help you kind of understand where we're coming from with respect to cash. But it's really about disadvantaged populations, being able to go to a grocery store and buy milk and bread and other necessities for their families.
Thank you.
Anyone else? Delegate Howard. You're mute.
Thank you, Mr. Chair. Kaylee, if you could just walk the committee through the pricing, I guess, cost structure between using cash, not using cash, debit and credit, because what people need to understand is that there's different pricing structures. For example, every time somebody uses a debit card in my store, it's 15 cents. Every time somebody uses that same debit card under a credit purpose, it's 8 cents plus a quarter basis point of the total transaction. So if you could sort of walk everybody through that and sort of outline the benefits of cash over credit and debit. And I know that's being done here, but just so everybody sort of knows that, that'd be great. Thank you.
I'll be quick. I don't want to belabor this. I think this will be helpful for Delegate Pippi as well. Debit fees on debit cards are set by the Fed. Credit card companies can literally charge whatever they want. So debit card fees, swipe fees, we typically see between 1.5% and 2.9%, although it can be higher. And then if a card is keyed in, you're talking about a 3.5% fee that retailer is getting hit with. So this is why my membership collectively said, number one, for the most part, we already accept cash. And for those who maybe don't, we'll create some exemptions for them. But this is something, back to Crystal's point, back to the delegate's point, where we're really trying to enable everybody who wants to make a purchase to do so.
Good, Delegate. Okay. Anyone else? If not, let me go to Steve Sakamoto Wingle, Office of the Attorney General.
Good afternoon, Chairman Davis, Vice Chairman Dumais, and members of the committee. Steve Sakamoto Wingle on behalf of the Consumer Protection Division of the Attorney General's Office here in support of House Bill 340. I'd like to thank Delegate Pena-Melnick for introducing this bill. When the pandemic hit and when we also engaged in the racial inequity issues that arose, the Attorney General formed an Access to Justice Task Force to examine these issues and to make recommendations. And when we noticed that some businesses were ceasing to accept cash payments, we determined that the impact was hardest upon those who could least afford it. The Federal Reserve has estimated that about 25% of the adult population is either unbanked or underbanked and doesn't have access to debit or credit cards, so they would be the ones who would be hardest hit by a business that doesn't accept cash. So one of the recommendations that came out of the Consumer Protection Committee of the Attorney General's Task Force was in fact this legislation. So we really would be supportive of the legislation. I have not yet seen the amendments that have been discussed. The one that does give me concern is the one about issuing a warning to the business first. I believe that that's already, I mean, although there's no formal warning, we wouldn't have the resources to be bringing actions against somebody when we get a complaint that a business is inadvertently not accepting cash because they didn't know that they had to accept cash. Secondly, if in the rare instance that we did decide to bring an enforcement action against a business, these civil penalties require us to take into account, prior history of violations, the good faith of the business, and other factors that would mean that the business would unlikely be subject to a penalty in any event. And in 99% of the cases, if we get a complaint, we're going to contact the business and try to resolve it through mediation. That's what happened when this General Assembly added a price gouging bill as part of the pandemic relief last spring. And when we've gotten complaints about price gouging, we've reached out to the business and said, hey, can you let us know what's going on here? And in almost every case, the business said, sorry, and has reversed the action or provided documentation to show they were not in fact price gouging. So we do support this bill. Once again, I do have concern about the warning amendment because I don't think it's necessary, but I would urge a favorable report. Thank you.
Any questions for Mr. Sakamoto Wingle? Seeing none. Delegate Howard.
Yeah, Steve. So walk me through this. Your contention is we don't need a warning in place?
That's correct. Yeah, the Consumer Protection Division, 99% of the complaints that we receive are handled through our mediation unit, where we'll reach out to the business, say, here's the complaint we've gotten. To the extent that there's a law that the business may or may not be aware of, we'll cite to the law and say, can you please, respond?
What
And
about
hopefully
the other
we'll-
1%? What about the other percentage?
The other 1% is, those cases where we think there's either a pattern or practice that we have established, a large number of consumers being harmed, or some kind of egregious practice.
But that falls under a lot of businesses. I mean, some businesses see hundreds of people a day, maybe 10, 20 people a day. That would establish a wide pattern. I really agree with the amendment of having a warning system, but okay, we'll talk about that later. So, okay, I just wanted to make it clear. So the Attorney General's position is no warning for the bill.
We don't think it's necessary. Yeah, thank you.
Anyone else? If not, thank you very much. Let me go to, is it Tanaya Moore?
Yes, Tanaya Moore. Thank you. Chairman Davis, Vice Chair, members of the committee. My name is Tanaya Moore, and I'm the Policy Manager for the Cash Campaign of Maryland. Thank you for the chance to provide testimony in support of House Bill 340. This bill protects unbanked and underbanked consumers who are more likely to use cash. For Marylanders who earn a low income, cashless transactions may be difficult. In order to buy merchandise without cash, a person must have some form of financial account. It's important to recognize the fact that not everyone has access to banks or lines of credit. The 2017 report by the Federal Deposit Insurance Corporation estimated that 6.5% of U.S. households were unbanked. In fact, according to this same report, 3.8% of Marylanders are unbanked. There was a 1.3% increase in the number of unbanked people in Maryland from 2015 to 2019. This report also shows that 19% of households in the metropolitan statistical area, which includes Baltimore, Columbia, and Towson, are underbanked. We see that a large share of the unbanked and underbanked are Black or Hispanic and earn less than $30,000 a year. My last point is related to the EIP, also known as the stimulus payments, and the stats for the Maryland, which can be found on the IRS website. We know that people who are single filers in Maryland are likely unbanked and therefore receive paper checks or debit cards versus direct deposits. We also know that significant percentages of those who earn less than $20,000 annually are more likely unbanked, regardless of their filing status. An outright ban on cash discriminate against those without credit or bank accounts, likely those who are low income, homeless, or undocumented. A cashless payment can be one option among many, but it should never be the sole option. For these reasons, we encourage a favorable report on House Bill 340, and thank you again for the opportunity to testify.
Thank you. Any questions from Ms. Moore? Seeing none. Thank you very much. Ari Plott.
Thank you, Mr. Chairman. Mr. Chair, Madam Vice Chair, members of the committee. Hi, I'm Ari Plott. I'm here from Boston and Plow Law Offices here on behalf of the Maryland Hotel Lodging Association. I'll be very brief. We just are here to ensure that the amendment was in place that exempted us, and I'm very happy to say that the sponsor spoke about it. So I just wanted to thank the sponsor for putting the amendment in, and thank you for your time.
All right, thank you very much.
Thank you.
Meryl Chertoff.
Yes, good afternoon. Thank you very much, Chairman. I'm happy to be here today. My name is Meryl Chertoff. I direct the Georgetown Project on State and Local Government Policy and Law at Georgetown University Law Center. I appreciate the opportunity to speak in favor of House Bill 340, the Cash Transactions Preservation Act. Most of what I had planned to say is in my written testimony and has already been stated by others who've testified, but I did want to emphasize two things. As Ms. Moore just said, there's a lot of data to show that a number of Maryland residents are unbanked. Disproportionately, they are people of color. A full 14% of Maryland residents who do not own their own home were unbanked in 2015. That means 1 in 7 people in the state of Maryland who are renters are unbanked. In a situation like the current one, the current COVID epidemic, that means that 1 in 7 people who are already operating at the margin economically would have trouble going into a store that did not accept cash for payment and paying for urgently needed groceries and medicines. That's 1 in 7 people who are renters in the state of Maryland. So I think that that's something to bear in mind, and certainly a reason that if this bill is passed, that it should not be delayed in taking effect until the end of the pandemic. I also want to echo what was previously said with respect to the low probability of any transmission of COVID through the use of cash. As most of us know who go into grocery stores, a lot of the people who are taking our money are wearing gloves anyway. So to the extent that there are any concerns from a public health standpoint, those are addressed by the precautions already being taken in stores. I do want to focus on one other thing, which is the question of what it means to go cashless from a privacy standpoint. Somebody already mentioned the problem of hacks, but the other problem with respect to cashless transactions is that the vendors are vacuuming up information about all of us as they take those cashless transactions. That means that anytime you go into a pharmacy, anytime you purchase a pack of cigarettes, anytime you make any sort of purchase, which may be of a personal nature, if you're doing a cashless with every swipe, you are sharing your information with people in the private sector who are consolidating and potentially selling that information. That's another reason why cash is a means of payment which preserves anonymity and preserves privacy. And so that's another reason that this is a bill which is significant, not only to people of color and people who are poor, but every resident of Maryland who hopes to preserve their privacy. I'd be happy to answer any other questions.
Any questions? Seeing none. Thank you.
Chairman, I have a quick question.
Who is this? Delegate Fisher.
Thank you, Mr. Chairman. I appreciate it. So Meryl, I just want to clarify, you work where?
Georgetown University Law Center.
You are a professor?
I am.
Okay. I didn't hear the beginning of your testimony, so my apologies. I guess my question is, do you know we've had a number of stimuluses, of course. How does someone without a bank account receive a stimulus check?
I don't know the answer to that, but I can certainly look it up and get back to you.
I mean, I guess it's a fair question, right? Because the purpose of the stimulus is, and I believe rightfully so, was to put money into the accounts of people who weren't working because of the simple fact that, the government shut the economy down. And it certainly made sense to do that. And I've always supported it, not that that matters one way or the other. But I'm just curious, as a professor at the law center there at Georgetown, just curious if you're wondering how someone receives that check, and I'm sure they're highly motivated to receive it if they don't have a checking account. I guess you said you don't know?
Delegate Fisher, I don't know the answer to that question, but it's an excellent question, and I'm going to go and research it as soon as I finish here.
Wouldn't they go to almost a bank or something like that?
So my other question was, Merrill. And the question is for Merrill because I know that everybody's time is very limited because we have other bills to hear. But my other question, Merrill, is as a professor at Georgetown University and as an educator, how do we get people to understand the importance of having an account so that they can actually, you know, pay for things and not just rely on cash? And I say that because the benefit of having an account is that you actually earn interest on the account, including on checking. So it's an education issue, I know. And as an educator, I thought maybe you could address that.
There are a number of programs that are being sponsored, in fact, by various aspects of the banking industry at the elementary school and high school level to teach financial literacy. I'm certain that the state of Maryland is supportive of those types of measures. And so that is one way to educate people. I do want to take issue with the idea that you're getting interest on your checking and savings account. Last time I looked, I think that the rate of interest on most checking and savings account is something like 0.01%. It's not like in the old days. I remember when I was a kid, the magic of compound interest where you could earn 6 or 7%, and it was amazing how much your money could grow. I wish that were true these days.
I certainly agree with you, Professor. I guess my question to you is given the point that you made, how much interest do you earn on cash under the mattress? It's probably zero, right? So you're much better off having an account than not. So I'm not really sure that's, you know, makes a lot of sense, because if the purpose is, and this is important to me because the last time we had the Great Recession, it occurred largely because of the fact that people bought homes that weren't qualified to buy the size of homes they were buying. They were qualified in many cases to buy a home, but not the size. And we had these loans that had these kind of time bomb interest rates. They were kind of teaser low rates, and they got larger. So the first thing we discussed in the General Assembly when I got there in 2011 was, you know what, how do we teach people financial literacy? And I guess that's where I'm going with this, because, you know, anybody can pass a bill to say, you know, you've got to accept this, you got to accept that, micromanage the business community. And certainly that may or may not have merit, because I haven't really thought this through yet, but it's a fair question because you're a professor. I mean, is there some other solution to getting people, you know, to get educated about the importance of a checking account? Because I agree with you, it's only might be a really low interest rate, but it's sure as heck beats having cash under the mattress where you're getting zero.
Well, I certainly agree with the delegate on the importance of financial literacy and teaching people how to save and take responsibility for their finances. But I don't think that's the topic of today's hearing, and I'd love to continue the discussion with you as to consumer protection issues, which is what I'm here to testify about today.
But it's okay. No, I certainly appreciate that answer. As a professor, it's a disappointing answer that you're more interested in consumer protection than you are in education for financial literacy, since these are interrelated about finances. But I'll take your answer, and I'm certainly glad that this is being recorded because it'll be a great thing to play later. Thank you, Mr. Chairman.
Anyone else?
Mr. Chairman, it's Johnny.
Delegate Mout.
Thank you, Chairman. And this will be a very quick question. I'm not sure which witness would be the best to respond, but and we're getting into this bill, and something struck me, and it strikes close to home for me, but a lot of small restaurants right now are trying to convert to online ordering. And I imagine the hotels, the hotel association, they like to be exempt. I know the restaurant association has not weighed in on this. However, I just want to share this with everybody on the committee because it may come back if this becomes law. Whereas, you know, most of these businesses that operate, they have a closed system for their business, and they're trying to change and do takeout business. In order to do that, they pretty much set up a whole separate ordering system for their operations. That ordering system includes no one coming in the business and no one going out of the business. It's supposed to be cashless, touchless. And that's the effort of the industry, is to say, hey, we are perfectly clean. We've got a way you can get your product and it's touchless. And so I have some concerns about a mandate on all restaurants or not having some sort of a waiver for a touchless type of operation. That may undermine the intent of the bill, but I just have that concern. I just want to share it for any of the witnesses if you've got a response for me. And I totally understand what the bill is trying to address, but that is a real-time concern. And I think it's something that if this were to become law, that one of us on the committee would hear about. I know I would.
I can answer it if you'd like.
Yeah.
Kaylee?
Yeah, so if you look on page 2 of the bill and go to line 13, this section applies only to in-person retail transactions, and the section does not apply to telephone, mail, or internet transactions. So I hope that addresses that issue, but if we have to go further, I'm sure we can figure something out.
Okay, that does, Kaylee. Thank you.
Any other questions from the members?
I think Lily has a question, Mr. Chair.
Delegate Shi.
Thank you, Mr. Chair. I wasn't prepared to comment on this until I heard some of the questions from my colleagues. I just want to share some personal perspectives here. I was an immigrant. I still am an immigrant. When I first came here, because I came from a very different market economy, a different political system, I had to adjust to everything in this country, including how you use cashless system to buy things. And I would say, for the most part, it was a learning curve, but for most people like me who had to come and overcome all kinds of linguistic, cultural, economic barriers, ultimately, we wanted to get on with the program. Ultimately, we all want to try to use the credit card and buy things while also use cash. So I don't think we should necessarily question people's motive for not using credit card or debit card. As a newcomer, it might take a few years for you to trust the system and get used to the system. Sometimes it's just lack of knowledge. So you keep using cash out of habit. But over time, most people do adopt and adjust and transition to different systems. I think the intent of this bill is to be more accessible to everyone so that they don't have to struggle and figure out as they try to struggle and figure out a lot of things in life,
Right.
Thank you.
Anyone else? If not, that will conclude our hearing on.
Mr. Chair, I had my hand up.
Actually, Delegate Wilson had his hand up.
Delegate Wilson, you guys jump in. If I don't see you, I'm going to keep moving. So you got to let me know if you're out there.
Apologize. And I guess I'm having problems with my video, so I apologize, Mr. Chair. Maybe you didn't see it. And my question, I guess, is for everyone. Because I understand parts of the bill, like they're just, I definitely agree. Is the goal to just allow people to use cash or to stop them from being punished? Because it seems like there are certain stores, like when I bought my car, they're not taking any cash. And I know that's a big purchase. That's not necessarily retail, but I understand not wanting to punish people who are in a situation where they don't have cash. But the goal of this business is to go further. If this bill is to go further and tell bills or businesses that they have to accept cash. Is there a middle ground, or we can just say, well, look, we just don't want you to be punished for the individual. You shouldn't be able to charge them more because they only have cash. Is there a middle ground we can reach here, or does it just have to be where we punish people who, because of their business model, decide we do not want to handle cash? Because like in my law firm, if I believe my law firm's in a dangerous area, I don't want to take cash because I may get robbed walking in or out or sitting in my building. That sounds like that would be a decision that I would make based on my circumstances. Because to me, most people don't ever want to say no to money. I know I don't. So I guess I understand the point about not, punishing people or charging a rate, but to force businesses to take cash if they don't want to, I guess that's where I'm just a little confused. Could somebody tell me, is there a middle ground, or is this one of those zero sum all or nothing bills?
So I may be able to answer that question. Can everybody hear me?
Oh, we'd wait for the chairman to call you.
Okay.
Yes.
So my name is Owen Rubel. I'm a software engineer, and I have actually worked with some banking software and everything. There are federal regulations on cash that exchanges hands, on minimums of 5,000, 10,000, things like that, that have to be reported to the FBI, specifically related to money laundering and things like that.
Correct.
So what you're talking about, especially with related to a large car purchase like that, that's a lot of money, a lot of cash exchanging hands. And that would have to be directly, I do not know why they did not even flinch at that, and they are requiring large cash purchases for cars. That's very odd, because that would have to be reported to the FBI and places like that on a daily basis. And that's something that they should not want to even bother with. And I suspect that they are not doing that, and they should be reported, and that place shut down almost immediately. And that is something that this probably is trying to reinforce, to try and should be reinforcing, saying small purchases like your taco truck are great, that's fine. But when you start getting to large purchases that are starting to deal with things like money laundering, yeah, no, you don't want things like that going on, where you're doing $5,000 purchases and $10,000 purchases all in cash that have to be like held in briefcases and stuff. That's where you're going, yeah, no, you shouldn't be running a business like this all in cash every single day, every single month, all year long, where you have a non-taxable income stream. Because when you're dealing with cash purchases, this is a non-taxable income stream that we're talking about as well. And that brings up another issue as well. So small things like taco trucks, okay. Big things like cars and houses and boats, all in cash, you're talking about non-taxable income, money laundering, and these are things that states and federal governments need to quash, shut down, and keep very, very close tabs on.
And Mr. Chair, if I just briefly, I know we're trying to get through, but because my issue is it says goods and services. So as again, my law firm, if I choose to not accept cash because I'm not safe, I don't feel safe, I feel I should have that right. I don't think I should be forced to take $500 in cash, $5,000 in cash, because I don't want to be walking around with that kind of money, storing that kind of money. I don't run a cash business. And again, my worry is I understand trying to take advantage of individuals who don't have bank accounts. I'm all for it. But to make individuals like myself say, no, I'll get in trouble if I tell one of my clients, look, you better go get a check or money order something because I'm not going to take your money. That's where my problem exists, because if that's the way I do business, if that's the way I want to run my business for what I argue is my own safety, or if I'm running a small store, if I want a 7-Eleven, if I don't want to be victimized, if I worry that if I keep taking large sums of cash or multiple cash orders in a day, that at the end of the day, they'll know that I have a large amount of cash in my safe, I think we still run the risk of, really going against the better interest of these businesses. So again, I understand the whole base thing. I mean, I'm a lawyer. I understand the IRS, anything over $5,000, $10,000. That wasn't my concern. It wasn't money laundering. It was protecting individuals. So I guess we'll discuss this in subcommittee. I apologize, Mr. Chair, for taking your time.
No problem. That's why we're here. All right, let's go ahead and end that hearing. That concludes the witness list for House Bill 340. If Delegate Love is with us now, let's go to House Bill 218. Delegate Love.
Thank you, Mr. Chair. Good afternoon, everyone. Chair Davis, Vice Chair Dumais, members of the Economic Matters Committee. I am Delegate Sarah Love here to present HB 218, which would put in place protections of our biometric identifiers, such as our fingerprints and irises. Thank you for passing this bill last session. Unfortunately, the bill ran out of time in the Senate due to our truncated session. So this year, Senator Augustine is cross-filing it. His hearing is today. It should be any minute. So we've all been anxiously waiting to see which committee would go first. The bill you have before you is the bill you passed last year with one small change. At Senator Augustine's request, it no longer contains the requirement that a company obtain written consent prior to collecting the biometric identifier. I would prefer to keep it the way you passed it, but the senator wanted to focus only on what happens once the company has the identifier. And in the interest of protecting these unique identifiers, I agreed. So I have a couple of experts here that will talk more about biometrics and the importance of protecting them. I just want to talk to you about some of the claims made by some of the opponents. First, they tell us that this shouldn't be done state by state, that there should be, national standards through the federal government, and that they believe that will happen under this administration. Well, uniform standards would be nice. I absolutely agree. But we cannot wait for if and when the federal government acts. If they do, great, then our law will be preempted. If they don't, then at least Marylanders are protected. Second, they're opposed to the private right of action. They're opposed to being sued by people whose biometrics have been used. And they would prefer instead that the Attorney General's office handle this. Well, of course they do. No company wants to be sued. We've talked to the Attorney General's office. They can't handle these. They just don't have the funding or the capacity, nor should they have to. Because let's remember what we're talking about here. Biometric identifiers are unique. They aren't like a social security number or your address, as one of the opponents said. If someone gets your social security number and steals your identity, it is a nightmare to work through to restore. But you can, and you can get a new social security number. You cannot get a new fingerprint. Another argument that they come to is that if you pass this, they will not be able to use biometrics for safe entry into a building or deploy safety and security systems. The bill doesn't say that. The bill allows companies to use biometric data as long as they exhibit a reasonable standard of care and have a retention and destruction policy. That's a pretty fair balance. So in conclusion, there are few rules governing the use of biometric identifiers despite the explosion of technology gathering them. And I gave you some examples last year. Happy to provide more of them to you. Senator Augustine and I were talking about, going to Disney World, and they take your fingerprint to get you in at the head of the line. That's great. But what do they do with that? Those are the guardrails that we're trying to put in. So we need these minimal guardrails because once this information is gone, that's it. You can't get another iris. I respectfully request that you again pass this bill so Marylanders have some protection over the use and retention of this unique and very personal data. Thank you.
Any questions for Delegate Love? If not, I'd like to go to Jeremy Scott. Are you with us?
Thank you, Chair. I am.
All right.
Dear Chair Davis and Vice Chair Dumais and members of the committee, my name is Jeremy Scott. I am Senior Counsel of the Electronic Privacy Information Center, or simply EPIC. EPIC is a public interest center established in 1994 to focus public attention on emerging privacy and civil liberty issues, and has long advocated for strict limits on the use of biometric data. Because of the sensitive nature of biometric data and the potential for abuse, I'm here today to testify in support of House Bill 218, as well as Senate Bill 16 regarding biometric identifiers and biometric information privacy. The passage of these bills will be an important step towards protecting the privacy of Marylanders. These bills are based on the Illinois Biometric Information Privacy Act, also known as BIPA. BIPA is one of the most important privacy laws passed in recent memory. BIPA, HB 218, and SB 16 set out a simple privacy framework to protect individuals' biometric information. Without these safeguards in place, it's clear we will begin to see more of our dystopian nightmares come true. Case in point, about a year ago, a report by the New York Times revealed that a little-known company by the name of Clearview AI had created a massive facial recognition database of billions of images scraped from all across the internet. Because of what Clearview AI did, we all likely have at least two things in common. First, all of us likely have biometric data, namely our face prints, in Clearview's database. Second, none of us gave Clearview consent to use our biometric data to create a massive database to be used for facial recognition searches by whoever Clearview decided to sell access to. Clearview has stated that it will no longer sell access to private companies and non-law enforcement entities, citing BIPA as the reason for this change. The reason BIPA caused such an about face from Clearview, but other biometric privacy laws like those in Texas and Washington did not, is because BIPA grants a private right of action. The private right of action is absolutely essential to these bills and is the most important tool the legislator can give Marylanders to protect their privacy. Like BIPA, the bills would impose an enforceable legal obligation on companies that choose to collect and store individuals' biometric data. History informs us that leaving the enforcement of privacy rights up to government regulators is not enough, and that private right of actions provide a meaningful deterrent that will prevent abuses. We saw this pretty clearly with the Federal Trade Commission's handling of Facebook over the years. Despite the FTC's long-standing consent order with Facebook that implemented certain privacy obligations and repeated warnings by Epic and others of potential privacy violations, the FTC did little to ensure Facebook was adhering to the requirements of the consent order, and the result was the Cambridge Analytica disaster, where Facebook allowed vast amounts of private information on millions of individuals to be taken and used for political ends. In response, the FTC did not require Facebook to change its business practices, but merely fined it $5 billion. No doubt that's a lot of money, but as if to indicate what that fine really meant to Facebook, immediately after the FTC announced that $5 billion fine, Facebook share prices rose 2%, increasing the company's value by $10 billion. Before I end, I would just like to urge the committee to think about adding back the informed consent requirement. Though notice and choice regimes are not sufficient to protect privacy, the consent provision has proven to be effective in Illinois because it's easy to enforce. Thank you for your time today, and I'd be happy to answer any questions.
Any questions? Seeing none, thank you very much. Drake Jamali.
Hello, sorry, do you hear me? Oh, there we go. Oh, thank you. Afternoon, Chairman Davis and members of the committee.
Mr. Chair?
Oh, yes.
I'm sorry to interrupt. I believe Mr. Jamali is in opposition?
Yes.
We're just taking them in order.
Okay, so you're not going through proponents first?
No.
Okay.
Just going straight down the list.
Okay.
Okay. Thank you, afternoon, Chairman and members of the committee. My name is Drake Jamali. As you can see from my background, I'm with the Security Industry Association, or SA. We're based in Silver Spring and represent companies in the physical and cybersecurity space, with over about 24 companies headquartered or working in Maryland. And I appreciate, again, the time to present our industry's concerns on HB 218, and one of them being the safety and security applications in this bill will be undermined. Biometrics, as defined in the bill, such as fingerprints, retina, and iris images, help businesses keep facilities, employees, and patrons safe by increasing the effectiveness of security systems. And at a minimum, we recommend that the bill include an exemption for security uses. And a perfect example of this would be the Washington State Current Biometric Information Act, which was passed in 2017. So this law actually requires notice and consent mechanisms for individuals, but provides express exemption if information is a furtherance of a security purpose. An example would be access control to a facility, intrusion detection on your own property, anti-theft, fire alarms, and also active shooter scenarios. And secondly, of course, as you've heard from previous individuals, the class action liability will actually reverse the adoption of biometrics for Maryland businesses. And we're just specifically talking about the private right of action labeled in the bill. This will have severe consequences for Maryland businesses, as we've seen in Illinois' BIPA law, which was passed over 13 years ago. And since its passage, no other state has passed a private right of action. And examples being Washington and Texas, which have labeled, the Attorney General actually take over this jurisdiction for violations. And we think that giving the AG's office will in our opinion, avoid the extremes and enforce the legitimate violations, and will actually protect consumers and private entities alike. And again, as Delegate Love said, if the AG's office doesn't have the bandwidth for that, maybe that is another discussion to have, increasing their funding for that. And that's something for further discussion. But these are two crucial concerns for our industry. And so we'd happy to answer any questions if you have any on that discussion.
Any questions? Seeing none. Thank you
No,
very much.
Mr. Chair,
I think that, yeah.
Yes.
sorry. I just wondered if you could tell us a little more about the private cause of action issues that you raised with reference to Illinois.
Yeah, so just a few examples from that. I mean, we heard that Facebook, but a few is Shutterfly, and I think maybe some of you might be familiar with this. It's a service it provides, so you can kind of allocate all your photos in kind of in a portfolio, and you can search your photos by of course location, but also you can use face. And if you wanted to search all the photos of your significant other or your father or brother, Shutterfly has that service for you, so you can kind of allocate all those photos of someone's face. And this was a case that we saw in Illinois during a private right of action, and it was seen as a violation. And now Shutterfly cannot allow that service to be used in Illinois for any consumers. Of course, we've seen other cases. Over about 800 lawsuits have been filed in Illinois since its passage, and we believe this has been detrimental to business. Services cannot be given for Illinois residents; they can be given in Maryland or in other states, such as Washington and Texas. They have exemptions for that. So,
and in the states where it's the Attorney General, do you have any information or numbers on the number of cases that Office of Attorney General has handled?
That's information I can circle back to you with. I don't have it right now.
All right, that would be helpful. Thank you, Mr. Chair.
Mr. Chair, I actually have a follow-up to Madam Vice Chair's question.
Delegate Crosby.
Yep, thank you. Mr. Jamali, I'm just kind of curious. First, you mentioned the Shutterfly case, and that surrounded the consent piece, but that consent piece is not in this bill, correct? Or if it is, can you please point to it where that comes in? Because I think that this bill actually removes the problem with the Shutterfly case. So can you expound on that a little bit more?
Right. So I believe that Delegate Love said that the written consent what was written out. The bill that I was, of course, looking at before this hearing still had the written consent in it. So maybe that was by chance an older version. But I think it's the implications of this, as well as having a private right of action. For anybody that can file a lawsuit, I think that kind of opens the door and floodgates for the trial lawyers. And I think that's where our industry is kind of coming at it. Is that anybody can file a lawsuit, and even if you're found to have a wrong lawsuit, you still have to pay fees for lawyers. And I think
just to counter that, I mean, I can file a lawsuit for anything, and anybody could have fees attached to that. So I mean, that's not necessarily entirely true. But and then my second question, you had talked at length about security, and I'm trying to figure out where in this bill it says that you can't take fingerprints or an iris scan. It says you can't sell it to another party, which is on page 5, but I don't see anything where it would prevent you from doing that. Can you point to the part in the bill, and maybe you have an older version, but where it says you're not allowed to do that?
So yeah, from our point of view, it's again, it's the idea of having this private right of action in the bill, as opposed to having the AG's office, have oversight over these violations. That is something that a lot of our businesses that are in the security and cybersecurity space, have concerns that somebody could file a lawsuit under those circumstances labeled in the bill, such as what we've seen in Illinois. And that's why we've had concerns over this. So we're thinking that, having that.
I guess the way I'm hearing you is it sounds like you just don't want oversight, but okay, well, we'll move on. Thank you, Mr. Chair.
Mr. Chair, I have a question.
Yes, sir. Delegate Adams.
Thank you, Mr. Chair. And I cringe every time I see one of these bills that come through, and I've been in committee for 7 years now, where we're using Maryland Consumer Protection Act to create the enforcement mechanism and or the penalties for violations. So I'm coming off of the fiscal note, and the question to the gentleman that's speaking is that this violation of MPIPA is going to be determined to be an unfair, abusive, or deceptive trade practice subject to Maryland Consumer Protection Act civil and criminal penalty provisions. So my question is, are you aware of what the criminal penalty provision is under Maryland Consumer Protection Act?
No, I'm not familiar with that.
It can be 1 year in jail.
Okay.
Does that seem heavy-handed to you?
I mean, yes, being that anybody could file a lawsuit, such as Delegate Crosby mentioned, I think that's a severe consequence of this bill that we could see if it was left up to private right of action.
So to be blunt, our Attorney General, Frosch, I would give deference if he brings a bill forward and says, I'm going to want certain action and powers, and I need this Maryland Consumer Protection Act to do that, because I believe that the Attorney General can balance the severity of the violation against the benefits to the state to act. What we're doing in this bill, which is broad, sweeping, and dangerous, is we're handing this to a plaintiff's attorney in the form of a class action lawsuit, where the punishment could very well be someone goes to jail. And I have to imagine that is chilling to the point where I've seen few bills come through in my 7 years more chilling than this. I'll surely ask the next proponent how they feel about putting someone to jail, and who would you actually put to jail. But I have to imagine this is chilling from your perspective, right?
Yes, correct. I mean,
thank you. That's it. Thank you very much.
Yeah.
Did I miss anybody? Not. Thank you very much.
Mr. Chair,
Yes.
can I go?
Yes.
Okay, I just wanted to back over you. I am a plaintiff's attorney, and my question is, are you aware of how much legal fees could be attached to a case like this, sir? How many hundreds of $1,000s you think I could stack up on a case like this?
What from what we've seen in Illinois, we've seen millions of dollars. I mean, in certain cases for private entities. So I mean that's where our concern is, that even if it's $1 million case, the plaintiff only sees a very small portion of that. The majority of it goes to fees and attorneys. So that's kind of where we see the issue.
And in fact, isn't it also true that these are actually, a lot of times we create cottage industries where attorneys, plaintiffs' attorneys, will go in and they'll sue for multitudes of millions of dollars on minor infractions. Isn't that true?
Yes, that's what we've seen in Illinois.
Right. I just want, because I do agree with my colleague about the dangerousness of using the Consumer Protection Act for any and every little thing, not even the jailable one. The jailable one is dangerous, but the amount of money that I can make on not even frivolous, because as you well know, and for colleagues listening, a lot of people don't want to go through the 2 or 3 years of court, so they settle. So again, I think it's very dangerous to be including this each and every time for some of these offenses.
Anyone else?
Yeah, Mr. Chairman.
Yes.
Yeah, Mr. Jamali, would you agree that there are major risks that are unique to biometric authentication that aren't present with other forms of authentication? Such as a password. If someone were to take your password and that's leaked, you can always go and and put in a new password, but you can't do that with your face. So So, and that being said, seem like, you need some more stringent, guidelines here.
Well, yes, we would agree as an industry that we pride ourselves on security and of course cybersecurity, but we think that the way the bill is laid out at its current state, it would do more damage than good, at least for industry and customers alike. And so I think that that's something that of course we're happy to have these discussions, and we're here to help craft better public policy and to help you with that. So.
All right, thanks, Mr. Chair.
All right, did I miss anyone? Not, thank you very much. The only other witness I have signed up as informational, and that's Pamela Dixon. Ms. Dixon, are you with us?
Mr. Chair, unfortunately, she is in the Senate right now. Our hearings hit at the exact same time.
Oh, okay. Well, she says she signed up for both oral and written testimony, so we will definitely read her written testimony. She was the last witness that we had for this bill.
Okay, thank you, Mr. Chair.
All right. As I noted, that concludes the witness list for House Bill 218. I'd now like to go to Delegate Carey for House Bill 148.
Thank you, Mr. Chairman. I just want to make sure that Assistant Attorney General Hannah Abrams is here with us today. I haven't seen her, but regardless, good afternoon, Chairman, Mr. Chairman, Vice Chairman Dumais, and members of the House Economic Matters Committee. Thank you for the opportunity to present House Bill 148. This bill provides necessary updates to the Maryland Personal Information and Protection Act and is supported by the Maryland Cybersecurity Council. As you may have remembered, we introduced the bill last year, worked extensively with the industry to arrive at an agreement on various provisions of the bill, but because of the early dismissal of the session, we got caught short. And since then, we've been continuing to work with the industry representatives to ensure that we're able to do two important things in this bill. One was expand the definition of personal information to include genetic information, and two, to streamline the notification process and ensure consumers are notified in a timely manner. Now, regarding the definitions, the data collection landscape has changed dramatically since the last updates to AMPIPA in 2017. As you know, technology's advanced significantly and provides consumers with a myriad of capabilities that back then seemed futuristic only a short time ago. For example, through services like 23andMe, people can discover their lineage and find extended family members. This is a great service, but your DNA is very sensitive, personally identifiable information, I believe, that needs to be protected. And second, with consumer notification, there needs to be quick in order to empower consumers to make necessary changes and protections to their accounts. So to that end, what this bill does is it tightens up the time frame of notification between the maintainer of data and to the owner of the data to 10 days when a maintainer became aware of a breach of their system. The other important time frame change is that the owner must notify the consumer within 45 days of becoming aware of a data breach, rather than after the conclusion of the investigation. This is important because investigations we've seen can drag on for months, if not years, rendering the notification at that point really meaningless. The other changes to notification is that consumers must be notified by direct mail, email, or telephone according to how they want to do business and how these businesses do business with their customers. Unless there's no other way to do so, substitute notice will be allowed, again, if the business has no way to choose one of these methods of direct contact. And I would point out, it's important to note that as we originally drafted the bill, House Bill 148 required businesses to send out notifications electronically, post them on their websites, publish to local media in addition. And what we've done is we've worked with the industry and we've taken that out. So your bill file includes an amendment that removes that additional information, only requires those types of notifications for companies who've had to resort to substitute notice. We arrived at what I feel is a good and reasonable compromise after working with a large group of industry leaders and the Attorney General's office. We believe that the work we put into this bill from all parties ensures that the consumers will be notified as they should while not adding undue burdens to business. For these reasons, I ask for your favorite consideration of House Bill 148 as amended.
Thank you much. Any questions of Delegate Carey? Seeing none. Patrice Drago?
She's not testifying, Mr. Chair.
Okay.
Just Hannah Abrams.
Is Ms. Abrams available?
I am. We're juggling.
Right. Welcome.
Thank you. Chairperson Davis, Vice Chair DeMay, thank you very much, committee members. My name is Hannah Abrams, and I am an Assistant Attorney General in the Consumer Protection Division at the AG's office. Thank you for letting me speak today. The Maryland Personal Information Protection Act, or MPIPA, is a data security statute that requires businesses, to collect consumer data to maintain it securely and to notify consumers and the AG if there's a breach. HB 148, with the proposed amendments that Delegate Gary has introduced, amends MPIPA to add genetic information to the list of personal information that businesses are obligated to maintain securely and updates some of the notification requirements and timelines. This is important because it's no longer just your doctor or healthcare provider that may collect your genetic information. And those entities are covered by HIPAA. Much of the time, genetic information, there are numerous direct-to-consumer businesses that offer people insight into their ancestry and medical risks based on a swab of saliva. This is interesting, but it also poses a serious security risk because those businesses do not have the same obligations that a healthcare provider has to maintain your data securely. This bill was drafted to create parity between the healthcare providers on the one hand and the other businesses that could collect genetic information. The rationale being that a private company that should have the same obligations to maintain your data securely as a healthcare provider, or at least the very same obligations. To that end, the definition of genetic information in this bill follows the definition in the Genetic Information Non-Discrimination Act enacted in 2008 and later implemented by the 2013 Omnibus Rule. The goal was to maintain consistency and try to simplify things. Why is this important? Way back in 2013, a study was published demonstrating that it was possible to re-identify your research participants using just your genomic data. If there's a breach, and you lose your genetic data, you can't get it back. Just like the biometric data, it cannot be returned to security. Collecting your sample also gives information about your relatives without even notifying them or asking them. So that kind of breach implicates a much broader swath of individuals. Adding genetic information to MPIPA simply means that if a company collects that data, they must take reasonable steps to protect it and keep it secure. That's all. HB 148 also updates the notification timelines and requirements. My office's experience with the current notification timeframes is that businesses are able to use it to drag out and delay notification. HB 148 remedies this by shifting the trigger for the notification clock to discovery of breach rather than conclusion of the entire investigation. Businesses are still allowed to investigate, but the investigation serves to toll the clock rather than delay it entirely. Many other states use discovery as the breach trigger as well. People deserve to be notified as quickly as possible about a breach in order to take the precautions that they need to. I will note that there's an amendment that Delegate Carey mentioned to the notice provision, and that's been negotiated extensively by many of the stakeholders in this case. Right now, consumers are not adequately receiving and understanding breach notices in all instances. That's because big companies are choosing to provide substitute notice, which just means posting on the website and in the media, instead of the far more effective direct notice, which means direct to the consumer. This was highlighted in Equifax when it first thought that 143.5 million Social Security numbers were exposed. It provided substitute notice. It later provided an additional 2.5 million people with notice that was direct when they revealed that there was more people that were impacted than they had previously thought. Our office received more calls from consumers following the direct notice to 2.5 million people than the substitute notice that initially went to 143.5 million people. Big companies have the option currently to choose the substitute notice because it'll save them money and it ends up limiting how many Marylanders hear about the breach and understand that it harmed them. Right now, small businesses can't even access that substitute notice. So this really only impacts the larger companies. This bill removes the option of substitute notice if it's only being done to save money. Finally, this bill gives some clarity about what the notice to the Attorney General's office should include, and so that we're better able to serve consumers when they call us with questions. Thank you. We urge a favorable report.
Delegate Wilson.
I apologize, Mr. Chair. I didn't put my hand down from before.
Okay. Any questions of the witness? Okay. Thank you very much, Ms. Abrams. Kaylee Locklear.
Hello again, Mr. Chair and honorable members of the committee. Again, for the record, Kaylee Locklear here on behalf of the Maryland Retailers Association. And I'm happy to say after 5 years of working with the delegate, we're actually here in support of the bill today. I've had quite a few conversations over the years, and this year in particular with him and Patrice, and I really want to thank him for that. And we do have one small tweak that we'd like the committee to consider. And I want to make it very clear that I'm not trying to get in the way of the bill's passage. So we understand if you cannot take this up for now. But because this bill is streamlining notification, it seems appropriate that we bring this up when we're taking a look at this section of the code. So the one remaining area of concern to us is with regard to actual notification. Currently, the law says, and this bill says, notification can be made via the phone, written notification, or by email, but by email only if a consumer has opted in. And we'd like to see that opt-in provision removed, as email notification is one of the most effective and cost-efficient ways to do so if a business does have someone's email and they've had a breach. The email that they would receive is in no way marketing or selling anything, just trying to achieve, I think, our common goal of notifying the consumer about a breach. And I'd just like to point out, many consumers' phones now block junk calls, and consumers tend to throw away what looks like junk mail. And by the way, neither of those modes of notification do any of us ever opt into. And I realize all notification has its challenges, but email should also be considered without opt-in. That way a business could include a link for more information about the actual breach, credit services, and things of that nature. So I'm glad to continue to have a conversation, work with the sponsor and the committee. Appreciate your time. We urge a favorable report. Thank you.
Any question of Ms. Locklear? Seeing none, thank you very much. Sean Looney.
Thank you, Mr. Chairman. Sean Looney from Comcast. I hope to be a lot briefer today than I was yesterday. we are favorable with the amendments as discussed by Delegate Carey. I just want to take my time to thank Delegate Carey. We know it's a lot easier to blow up bridges than to build bridges, but he was willing to spend a lot of time and energy on building this bridge between the industry and the Attorney General's office. A lot of time, a couple of Saturday afternoons, he and I spent some time on the phone, but I thank him because he wanted to make sure we got this right. And I appreciate the Attorney General's office for working with us and being willing to consider our concerns with the bill as originally drafted. And of course, Patrice for all her hard work on this legislation too. So thank you, Delegate Carey and Patrice. I know you're listening.
Any questions of Mr. Looney? Thank you very much. Andrew Kingman.
Hi, good afternoon, Mr. Chair, members of the committee. My comments are very much in line with Mr. Looney's. We worked with Delegate Carey's office over the past couple of years on this, as well as the Attorney General's office, and have come in support of the amendments that Delegate Carey offers. We think that strikes the right balance and appreciate our work. I represent the State Privacy and Security Coalition. We're 29 companies across a wide range of sectors in 8 trade associations. So, we appreciate his consideration in making sure that, our concerns were heard and that, companies will be able to more easily comply with these, with the bill moving forward here. So much appreciated. And just wanted to add on to Delegate Brooks's concern with the last bill about biometric data security. I would just point out that,
sir, we generally don't go back and testify.
Oh, understood. Bills. I was just going to say that biometric data is included in the data breach statute, and just for his edification there. So that's all I was going to say. Thank you very much for your time, and enjoy the day here.
Any questions for Mr. Kingman?
Well,
Delegate Howard.
Well, I'm sorry, Mr. Chair. My question's for anybody. Is that all right?
Yes, sir.
Okay, so are we putting the onus of notification back on small businesses? Because as the bill reads, at least that's what I'm reading. We worked very hard with Sean and other parties to make sure that that wasn't happening. My biggest fear here is that, our liquor stores that offer a rewards points program, the car wash in Edgewater that offers a rewards points program, they do that through owning, licensing, leasing, and maintaining data of their customers. And sometimes they'll do that through a third-party vendor like Comcast. I mean, if Comcast is breaches the onus back on the small business, which we fought very hard to try to remove, is the onus back on the business, the local business, to notify, I don't know, a lot of these Chick-fil-A's are franchises, and you'll get something in the mail from them for your birthday, 10,000, 1,000, 20,000 people of a breach. Anybody want to take a stab?
I can take a stab if that's okay.
Yeah, is that Hannah? Hannah, yeah, you take that one, because I don't think there's any change to that in this legislation. But
well, we finally got maintains in there, which was great. We fought for years.
This doesn't.
And I thought we were going to have to take hostages to get that word in, but we finally got it in. But that's good. But yeah, I'd like to hear everybody's response on that, because that's part of MPIPA's one of my babies, and that was part of the concern, was the notification on the backs of small businesses to 100, 1,000, 10,000 customers.
Delegate Howard, this doesn't change who has to notify. It just changes the way that they notify. So if, the Comcast was breached, Comcast is still notifying.
Mm-hmm. Okay. So Comcast will notify. Okay. So if, just for clarification again, I'm not trying to drag it out, but we fought long and hard on this. So if information that I have as a business owner is kept on and maintained on a Comcast server per federal regulations, let's say like a credit card information or whatever, that's my data, but it's maintained on a Comcast server. If Comcast is breached, I'm not under any obligation per the state's attorney as a business owner in Maryland to physically notify each and every customer.
This law and the amendments to this law do not change any obligations that existed beforehand. This does not alter those notice obligations. It just changes the method.
Okay, thank you.
Anyone else? Not, thank you very much. Neil Karkanis.
Good afternoon, Chairman Davis, members of the committee. Neil Karkanis on behalf of the League of Life and Health Insurers, as well as the American Council of Life Insurers. I just want to say ditto. We appreciate Delegate Carey and Patrice and everyone else's efforts throughout this amendment process, throughout the interim, and we're okay with the bill as is. So thank you very much.
Questions? Seeing none, thank you very much. That's the witness list for those wishing to orally testify. So that will conclude our hearing for House Bill 48. I will now go to our last bill of House Bill 84 and Delegate Feldmark. Delegate with us?
Thank you. Good afternoon. Thank you, Mr. Chairman. Thank you to all the committee members. It's my pleasure to be with you again to talk about right to repair, House Bill 84. And this bill is basically the same as the right to repair bill that we discussed last year. And as you may recall, the basic premise of the legislation is incredibly simple, right? When people own things and those things break or stop working, then people should be able to get those things repaired, okay? So it's pretty straightforward. What's the problem then, right? The problem is that as digital electronics have worked their way into more and more products, those products have become more difficult to repair. And manufacturers are increasingly making it difficult or impossible for consumers to repair their products. As a result, consumers spend too much money on either overpriced repairs or replacement products if the repair is impossible. Electronic waste is an ever-growing burden and problem for our environment. And small businesses that provide repair services are hurting as a result of this. And the problem extends to all types of products, including medical equipment. And several weeks after we discussed last year's bill, state treasurers across the country joined together calling on ventilator manufacturers to release the manuals and software needed to allow hospital technicians to repair ventilators so that hospitals weren't without equipment while they were waiting on a manufacturer's technician. So these are problems that range across all types of products, and this bill provides a solution. And the solution is that the manufacturer of the equipment has to provide on reasonable terms the documentation, tools, special equipment needed to diagnose, maintain, and repair the products they produce. And this is based on the voluntary right to repair agreement that you may be familiar with from the auto industry, right? So you can take your car to any mechanic and they can get the right schematics and tools and access codes to be able to repair your car and get it back to you. So, I think it's also important to talk about what the bill does not do. It does not infringe on copyright or intellectual property or warranty protections, and it does not compromise safety. These repairs that independent repair folks or owners may attempt to make, the repairs can physically be attempted without this, but having the right tools, the right information, the right manuals and documentation makes that repair safer. So We are in the process of working on a few clarifying amendments to address some concerns that have been raised. One is to just clarify that this is about a right to repair, not a right to disable or override safety features or emissions controls, and things like that. Also, we want to clarify that right to repair belongs to the owner of a product and would only extend to for leased items. That right to repair would be subject to the terms of the lease agreement. The owner could choose to extend that right to repair or not within the terms of the lease agreement. And also, just to clarify that this does not give the right to access source code of any proprietary embedded software. This is only talking about the software that is needed to make repairs to the equipment itself, to the product itself, not to access any content of an electronic product. So I ask for your for your support, ask for your favorable report, and happy to answer any questions.
Any questions of Delegate Feldmark?
Mr. Chairman.
Let me go to Delegate Wilson, then Delegate Valderrama.
Sorry about that. Delegate Feldmark, I don't know. I know you have people testifying, and I don't want to corner a colleague into some legal. Would you rather me wait to ask some legal questions, or would you feel comfortable answering them?
I'm happy to hear what they are.
Okay, I'm not trying to corner you and get you to, I just, yeah. Okay, so because in reading this, and you mentioned several times the word owner, but as I read the legislation, it also says independent repair provider.
Yes.
Now, do you know what it takes to be an independent repair provider? And that's, I'm not trying to trick you.
What it takes, I don't know what it, do you mean in terms of particular certifications or?
No, I mean, and again, this is why I was asked that's why the precursor question. But the way I read this, I can basically open up an LLC, CT Wilson's Apple Repair Shop, call Apple and say, I need all of your, all of your information.
The documentation, right.
Your documentation, parts, tools, updates, embedded information, including software, to not only disable your security, but work on that by just telling them I am an Apple Repair Shop. Because as I read it, it actually differentiates between an independent repair person and an authorized repair person. Mm-hmm. So that's, first of all, that's my understanding as the law's reached, that there is no requirement other than me saying, I don't even have to own the equipment. I can say I'm a repairman. I want this information.
So I appreciate the question. And if this is a definition we need to tighten up, I'm happy to, because I think I understand your point, and that is certainly not the intent.
Great.
So I would, if you have suggestions on that, I'd welcome them, but we can certainly spend some time working on it, and other panelists may have more specific suggestions, but me, conceptually, I agree with you completely.
And I watch YouTube. You have other panelists out there that make wonderful videos of me, so I will enjoy their conversations as well. That's why I was wanting to make sure that you and I did it cordially, because I did not think that was your goal. And you kept saying the word owner. And that's why I was because this is a national movement. This isn't just Maryland. They're doing this in every state. No state has passed it for the very reasons I've been articulating. But because it goes so far beyond me as an owner, what I want to do with my Apple, it is basically a repairman saying, I'm going to do it. Give me everything. And if I get something I can repair, I'll use it. That's how I understood it.
Yeah, I appreciate that. And I think my emphasis on owner was because the last conversation I had about the amendment we're working on was talking about leased equipment. And so I really focused on owner versus leasing. So
I was saying, I feel you like that. Certain things like a cracked screen. I mean, come on, I shouldn't have to send it back to Apple. I get it, but that's me as the owner, not the person making money on this. So I wanted to make sure that your intent is not just the owner of the equipment. It is also these, the legal definition was independent repair providers, correct?
Right. So it is defined in the bill. It says offers the services of diagnosis, maintenance, or repair of digital electronic equipment and is not an authorized repair provider.
Correct.
So I see your point. Does that, if I hang a shingle, I don't,
Right. So, and again, that's what, because I'm trying to, and also to your understanding, if this bill passes, somebody goes in because now they have the right to do this. Are they, will the warranty be voided?
So my understanding of this is that the warranty, this legislation does not impact warranties, right? So third-party repairs for repairs that may not be covered for warranty on a product that is still covered by warranty, that's covered under federal regulation. So this would not change or negate the terms of any existing warranty.
So, because that's also of concern that the warranty that's created wasn't created for an individual who Apple hasn't even trained to go in, flip it open, look around, hopefully not drop something, however they want to do it, close it back together, and then say, wait, my phone doesn't work, Apple, now you fix it. And my worry would be that when you have an unauthorized, not the authorized dealers, because I understand that they work within the confines of whoever they're working for, be it Apple or whoever they're trained for. I know when you go to an authorized repair shop that they will keep it under warranty. These independent repair shops, I don't believe, to my understanding, that it will stay under warranty depending on what they do. And that's another concern I have.
Right. So my understanding, and I'm just flagging this so that hopefully some of my other panelists can address it in greater detail. But my understanding is that there are federal laws and FTC regs which already cover third-party repairs for products under warranty.
Yes.
And this would not change that.
And it's only if they're authorized, to my knowledge. But I'll move on.
Okay.
And it also talked about trade secrets. The way the language is, it's a little loose in here as well. It makes it very clear that except as necessary to comply with the terms of the subtitle, original manufacturers basically don't have to divulge trade secrets. So that's a very tenuous thing we're talking here. You're saying except to basically comply with this, you don't have to give trade secrets away. So basically, you do have to give trade secrets away if it's something that they need, and they say that they need this to fix the product. That's my reading.
Okay, I mean, my understanding is that the types of repairs we're talking about do not require release of trade secrets. So we can take a closer look at that as well.
And remember, I'm asking this for your intent because at the end of the day, it's not the stymie growth or small businesses. But I want to say, as it's written, it doesn't preclude them from saying, no, I need that. I don't care if it's a trade secret. And I say all that to end with this, because the worry is, as we've discussed before about our commercial law and our Consumer Protection Act, there's jail time involved. Because, and is that your intent, that when this happens and it doesn't happen the way we want it to, that person get locked up?
That is not my intent.
And again, I'm sorry if I'm being rhetorical.
Yeah.
I know you well enough to know that's not your intent, but that's unfortunately the situation that we're moving into, and opening up for for obviously, people like me to be big plaintiffs against Apple and rake in millions of dollars for the civil side. I just wanted to make sure I understood your view of what you thought we were doing.
Right. And I just want to add, it's not my intent to incarcerate anyone else, right? It's my intent to get people access to repair their products.
Right.
So, I think that's probably a broader issue with this area of Maryland law, not necessarily specific to this bill, but I appreciate your point.
No, and it's just, as lawmakers, we have to look at the broad picture of the laws that we're passing and the way I interpret this law. And I see a lot of people dancing in the weight room, so I'm sure I'm going to get some more feedback on it. So, but thank you very much for your patience and your time, hon.
No, thank you.
Any other questions for the delegate?
I was next.
Valderrama?
Chairman. Yes. Delegate Fulmerk, thank you. I was patiently waiting. My colleague CT Wilson tends to go on and on and on. But having said that, he kind of piggyback touched on what I was going to say. I'm flying blind here, so forgive me. I'm having issues getting onto the House Floor system, so I don't have any documentation in front of me. But I'm familiar with you bringing this. But I recall that some of the issues, and one of them was the major one was the copyright issue, and Delegate Wilson kind of put on that. But you said there was no language in there, and from what I recall from last session, there was a big issue with writers and copyright issues, and that was not your intent. But I don't have it in front of me, and I think Delegate Wilson referred to it. So will that be coming out of the bill if it is in the bill?
So I don't believe copyright specifically.
Well, it was more so
in
also
the bill.
It was more so also how Delegate Wilson touched on.
Oh, the trade secrets piece.
Correct. Yeah.
Okay.
Yeah. So yes.
Yeah. So I don't have a specific amendment to remove that, but I think I understand the concern, and we can certainly look at that.
Thank you. That was it.
Any other delegate with the question? If not, I'm going to return to the list. Amy Marin.
Marin, thank you. Can you hear me?
Yes.
Okay. Good afternoon, Honorable Chair and Vice Chair and members of the committee. My name is Amy Marin, and I'm testifying on behalf of the more than 75,000 members and supporters of the Maryland Sierra Club. And we urge a favorable report on House Bill 84. The Sierra Club has also submitted written testimony on this bill. Right to Repair embraces the concept that durable products that break can easily be repaired because the manufacturers make their service manuals and replacement parts available. We already have Right to Repair for cars. Local car mechanics are given access to all the same software diagnostics and service manuals that the dealerships have. This bill will reduce digital electronic waste. Every year, large numbers of otherwise repairable and usable consumer electronics, such as smartphones, are unnecessarily discarded, with many ending up in landfills or incinerators. In fact, the lithium batteries in those phones can also be incredibly hazardous if placed in incinerators, as we have had fires at the Montgomery County incinerator. And one reason is because the manufacturers have these basically and effectively a repair monopoly over these products. This results in higher costs to the consumer. It frequently means that purchasing a new phone is either a better bargain or the only choice. Imagine if your car, like an Apple iPhone, could only be repaired by the original manufacturer. Right to Repair is not just about reducing the amount of discarded electronics. It also reduces the wasteful and environmentally harmful production of the mined raw materials that form the guts of these products. In one study, production of a single iPhone 6 was found to have used 295 pounds of raw materials, 34 kilograms of ore, 100 liters of water, and 20.5 grams of cyanide. Finally, HB 6084 will help the economy by generating new jobs in independent repair industries. It will help create competition in repair services that will save money for consumers. In sum, Right to Repair is a zero waste, circular economy approach that reduces waste, preserves valuable natural resources, mitigates pollution of air, land, and water, increases consumer choices, and boosts the local economy with new jobs in the independent repair industry. Thank you for allowing the Sierra Club to share our views today.
Thank you. Any questions for Ms. Marin? Seeing none, thank you very much. Emily Scarr.
Hi, Mr. Chairman, Madam Chair, thank you. My name is Emily Scarr. I'm the director of Maryland PIRG, which is the statewide consumer group. We support HB 84, the Right to Repair bill, or like we call it, just let us fix our stuff. I believe we had this hearing on March 11th, my last public appearance before I went into lockdown with my family and my kids. So it's nice to see everyone again. I will try not to repeat myself from then, but just say that I think this year has laid bare why right to repair is so important for Maryland consumers and Maryland businesses. When we shifted to remote learning, Maryland families in our schools were strapped to make sure that our children had access to the digital devices they need. There was such a crush in the supply chain that people were left unable to have access to education. And one thing that Right to Repair will do is help close that digital divide by making our everyday devices last longer, saving dollars for individual families in our school districts. As you heard from Delegate Feldmark, we saw that our hospitals had their equipment pressed into service and they weren't able to maintain ventilators and other life-saving equipment. Maryland Treasurer Nancy Kopp joined our call, pushing ventilator manufacturers to make some of that repair information more available, and they finally did. But this just makes clear why pushing voluntarily industry to do it isn't good enough. It took a law in Massachusetts before the car industry came to a voluntary agreement nationwide, and it's probably going to take a law for the rest of the industry to move along too. It's particularly harmful for small hospitals where they're locked in these very expensive contracts with manufacturers to maintain hospital equipment. And it's harder for independent techs to get out to the hospitals to repair them. And then finally, as we deal with the economic fallout of the COVID-19 crisis, I think it's important to realize how much money this will save Maryland. Maryland PERG actually released a report just last month that found that right to repair legislation would save over $300 per family a year and $735 million all told for Marylanders on the money they spend on electronics. And not only that, but the money we do spend on our electronics, more of it will be spent on repair economy, keeping it locally within our small businesses and in Maryland, instead of needlessly shipping all this money overseas to buy new electronics all the time, instead of being able to maintain the equipment we have. And I think you'll hear later from the Farm Bureau. We were hopeful that the farmers would be able to reach an independent agreement with farm manufacturers, but I don't think they've been able to do that. So it just really impacts all aspects of our life. As I hope will be clear, and we have some more experts coming on with legal background, we want to make sure we can address any concern anyone in the committee has about intellectual property, copyright, warranty. This bill should not affect any of that. The delegate is already working on some technical amendments to try to even make that more clear, but just so you know, that's not our intent or the intent of the delegate. And so we're happy to continue to work with the committee members to make sure it's all clear in the legislation. So we strongly urge a favorable report.
Any questions for Ms. Scar?
Mr. Chair, I have a question.
Delegate Pippy.
Thank you. I guess this is a question for Mrs. Shar. So Mr. Shar, I'm looking at the bill, page 4, and basically for the independent repair facility, you know, part of the bill says that, and I'll just read it, an original equipment manufacturer shall provide any documentation, parts, tools, or updates to information or embedded software. And then number 2 under that, it says, as it applies to equipment that contains a security-related function, any documentation, tools, parts. So, you know, and thinking about what makes technology valuable, it's the R&D that goes into it. I mean, there's a lot of these companies that it's not the plastic you see before you, it's the technology, the amount of effort they put into it. And you have to be somewhat concerned that with this bill, it says any, I mean, shall and any. I mean, that would include, in my eyes, all the trade secrets, all the, you know, you could reverse technology, everything. You could figure it all out, reverse engineer. There's really no ambiguity in the way that's written, in my eyes, because it's a shall and any. And you could say, well, the intent is not to find out what trade secrets are. The intent is not to find out what the technology is, but you couldn't prevent thousands of people from just unlocking, looking through, piercing. I mean, so if you could just address that for me. Thank you.
Yeah, I'd be happy to. And someone else later might have a better answer. But I would just say 2 things. One, that already the information they're giving is the same information they're giving to their licensed techs. And we have no problem with them creating a licensing program or anything like that to make sure that the people that they're sharing, this isn't saying you just freely give it away. You know, that they have reasonable terms. They can charge for it, whatever you say. I don't think they want to be sharing that information with the guy who works at the Apple store as a genius. So I don't think they're going to be wanting to share it either. I think the reason that language is in there, frankly, is because otherwise they could say anything's a trade secret and not give it away. No one wants access to that information, and anything we can do to make sure that it's not requiring it. But all this information is already being made available in ways, either to their own repair technicians or to the folks they have a legal agreement with and are charging them to get it. So there is a way for them to give this information without disclosing trade secrets. And we're just asking for reasonable access for that for the general public and for independent repair shops. So I understand where that language might be scary, but it shouldn't actually require that. And in fact, is there for the opposite intent to keep businesses from saying, oh, I can't give you this diagnostic software because it is it's our research. I hope that makes sense.
It does. And just my last comment briefly, it's just, I don't want to oversimplify it, but the product, if the service sucks, you could just stop buying it, go to a competing company. So it overcomplicates things there, but thank you very much.
And Delegate Pippi, can I address that? Because I think you were really focused on any and that opening it wide up to absolutely anything. But I want to draw your attention to page 3, lines 17 through 19. This entire subtitle applies only to the documentation, parts, tools, or updates required for the diagnosis, maintenance, or repair of digital electronic equipment. So it is already limited to only that information that is needed to make the repair. It's not as broad as it appears if you only read the provision on page 4.
Thank you.
Thank you, Delegate Feldmark. Are there any further questions of Ms. Scar? Seeing none. Thank you very much. Owen Rubel.
Right here. Can you see me?
Mr. Rubel.
Speaking.
It's your turn to testify.
Okay. So my name is Owen Rubel. I'm an original.
We can't hear you, or maybe I can't.
I'm off mute.
Okay.
Can you hear me now?
It's a little better, yes.
Okay. So my name is Owen Rubel. I'm an original member of Amazon from 95 to 98. I seem to hear this same argument over and over about trade secrets. So something with any product, if you have sold it to me, if you sell me a car, boom, that is my car. I own it now. I can rip it apart, pull it apart, piece by piece by piece, lay it all out on a tarp, see how every single piece works, put it all back together. Every single trade secret is lost once you have sold that to me. Trade secrets are no longer an argument here. So let's get that off the cart, okay? You can't argue trade secrets. You've sold me the product, I own it, I get to do what I want with it. This argument is about repair and whether we can create jobs to repair these devices, okay? Whether we can get the documentation, the products, and create certification for repair, just as we have always done in this country. When we had the Industrial Revolution and we created new jobs for cars and air conditioner repair and refrigerator repair, we did that. We got the documentation, we got the products and the parts from the manufacturers and Ford and Chrysler and everything. And they worked with small towns and local shops to repair cars and refrigerators and air conditioners. And in fact, our high schools started small programs, metal shop at our high schools to educate our graduates so that they could go out into the workforce and start creating jobs and working in jobs immediately from high school. This should not be an argument. We should not be even having this discussion at a time when small businesses are going out of business day in and day out. And billion-dollar corporations are the ones fighting this. It's not an argument. 63% of people right now in COVID, according to CNBC, are living paycheck to paycheck. And this is their only lifeline. This is their lifeline to a job, to food, to a home, to staying in their homes for their families and their children. And these billion-dollar companies are saying, send your lifeline away for a month, when we can be creating jobs to repair this locally and just have it back into their hands immediately. This is what we're fighting for. We're fighting for that certification that we were just talking about, that certification for Apple to say, yeah, absolutely, this person is certified, so now we can ship them the parts. So now we can ship them the tools because we know they're certified and we know we can trust them. So I don't see why everybody is fighting so hard against this when this can create those jobs. When we can get those graduates from high school to move from an industrial way of thinking to a digital way of thinking and create those jobs in those local economies where people are so angry that they no longer have manufacturing jobs, and we can offer them digital jobs locally. You know, this is a great solution.
I thought I had a ball here. He's a ball right there.
Oh, I apparently lost something.
Delegate Turner, mute yourself.
Well, I'll yield the floor regardless.
Mr. Chairman.
Delegate Adams.
Thank you, Mr. Chair. So the bill, and by the way, I'm completely opposed to the bill, so not to dispense with that. The Consumer Protection Division has the same violation provision where $10,000 for each violation, $25,000 for repetitions, and then a possible criminal penalty, which would be jail. Let's say this bill does get through. Would you accept an amendment that would allow these owners of the intellectual property and the equipment to in fact turn around and impose those same violations on these independent service providers that would use the information, the details to crack the code or to break the safeguards that are in place by the manufacturer? Would you support a amendment that I would put in that would put the violation, including criminal penalties on you as the independent service
It strikes me to just pass on a little bit more that might be helpful to you.
Delegate Watson.
Remember that Howard County government gives Howard County Hospital
Delegate
money
Watson.
for capital.
Delegate
At least
Watson.
Calvin has in the last,
Delegate Watson.
more so than Kittleman did, more so than Ruby did, right?
Delegate Watson. Go ahead.
Are you talking China? Because these parts and the manufacturer of these parts are in China or Taiwan or whatever.
It's a yes or no. It's a yes or no. Would you support?
It's actually not a yes or no. The manufacturer of these parts that you're talking about are in the Philippines or China. These guys, Apple and what, are merely middlemen who take these parts from other manufacturers and put them together into a machine. So if you're asking about the manufacturers of the parts, I'm totally against the Philippines and Taiwan and China spying on us.
I'm asking if you are the service provider that gets the information.
You're asking about middlemen then.
I'm sorry. I think I'm being fairly straightforward. This is a bill.
It's not a yes or no question. I apologize. Then I would have to answer you that it is not a yes or no question, and you're asking for a yes or no from something that is not that simple.
Then you're okay. Okay, so then you're nonplussed by my question. You're agnostic. You really don't care whether I would put an amendment in there that would.
My answer is that you are not asking a yes or no question, and I cannot answer that.
Okay, guys, this is going nowhere. I think we understand each other on that point. Let's move on. Delegate Wilson, Delegate Brooks, and then Delegate Mounts.
Yes, sir. Just briefly, two statements kind of caught me off guard about the whole trade secrets. And basically, the example you gave about is taking apart a vehicle or a product and knowing everything, there are no trade secrets, then why are you asking for a book or a manual? Because clearly you don't need it. Secondly, when you say there are no trade secrets, I beg to differ because Maryland, Uniform Trade Secrets Act 11-1201 specifically says that this is trade secrets are information, formal pattern, compilation, programs, device, method, technique, or process that derives independent value, not generally known, not readily ascertainable by any proper means, and the important part that I'm stuck on, can obtain an economic value. So
Yes.
clearly what we're
Keep
talking
that in
about
mind.
are trade secrets because you're asking for them to obtain an economic value.
Keep
So
in
to
mind
say
the
that
wording.
Maryland doesn't have trade secrets is somewhat of a misnomer because we have it defined by law.
Well, can you read that back to me one more time, sir? And just read it back. No commentary, please. Just read back what a trade secret is, please.
No, I was literally
Okay.
just, I mean,
Well, let me answer then. It says that is not clearly known. Now, once you sell that product to me and I can take it apart, I can clearly know everything about that product, correct?
Okay.
Correct?
No, because you wouldn't need
No, wait. I can clearly know everything about that product. I can pull it apart and I can see all the parts.
You don't need to ask for a tool, sir. Then what are you asking for if you know everything? What would you need access to? Why would you need a manufacturer to give you anything? Hence the trade secret.
Then I will tell you. They control the supply line to all of those parts. They control the supply line to all of their parts. The parts come directly from Taiwan to them, and I cannot get access to their supplier except through them. I can see all of the parts, but in order to get those parts, I have to purchase another phone, which I could swap out the parts. So there is no trade secret, but I still need those parts to repair this.
So basically manuals and software, we can delete out of this and just talk about parts now, because you clearly don't need manuals and you clearly don't need software. All you need are parts, and a 3D printer might cover that. But
incorrect. A 3D printer does not print out the electrical components and the, like, for instance, the processor and things like that. Also,
my point,
it depends upon the manufacturer to manufacturer. Some manufacturers do give you the parts, some don't. And we're not talking about any manufacturer in particular here.
Sure. I was just trying to explain to you that right now we do have trade secrets under Maryland law. We actually have violations for stealing trade secrets. And this is in direct tension with that. But I'll cede the floor.
Not if you can open it up. If I can see everything about the product, there are no more trade secrets. The only thing that there is a supplier secret that you have here, in the fact that you're not allowing me to get the parts to repair it.
Sure thing. Thank you.
There's no trade secret, though.
Delegate Brooks.
Thank you, Mr. Chair. Yeah, Mr. Rubel, yeah, I'm of the belief too that if I buy that product, then I own it. And oftentimes, if I'm trying to do a repair, oftentimes if I want OEM, I'm going to have to go back to that manufacturer anyway to get those parts, you know.
Yeah.
So, and right now, if I were to try to repair something, matter of fact, through personal experience, my dryer about 3 weeks ago stopped heating.
Oh.
So, you know, just figuring out, well, if it stopped heating, there's one of two things, then that means that it's either the igniter or one of the coils. So I bought those two parts, I ordered them from the manufacturer, you know, and put them in, darn thing still didn't work. So I said, well, what else could go wrong? So, but there is what they call the schematics or the diagram.
Yes.
Yeah, for you to do the troubleshooting. So I went through the schematic, the troubleshooting, and I found out, you know, I was able to identify what the next solution would have been, and that would be the flame detector. Ordered that, a week later, that came in, and then now the dryer is heating, you know. So, but I wanted the ability, since I made that purchase, that is my dryer, I own that. I was able to secure the parts to get it. And if it didn't work, then I could go, if I choose to go to that authorized repairman to get it done. But I did want the option to make that particular choice, you know. And right now on page 2 of the bill, lines 26, it says documentation means a manual diagram, reporting the output, the schematic diagram, you know, these are the things that normally, at least you used to get. I mean, I got,
yes.
I mean, that that diagram was in the back part of the dryer itself, just in case the person wanted to try to fix that him or herself, or if you were to get an authorized repairman, that's there for that person as well. So I don't think we should deny an owner of a product the ability to try to make the repair if they can, especially if those parts are coming from the manufacturer anyway.
Absolutely. If I may redirect, just a couple months ago, I have an espresso machine. I'm from Seattle. And I have a double burr grinder to grind the beans. And suddenly it stopped working. And it was the switch on the front to power it up, to turn it on. And I thought, well, this thing cost me $500. And I've only had this 1 year. This is ridiculous. And I was like, well, there's no way that I'm throwing this away. This was $500. And so I was like, well, the most obvious thing is this switch right here in the front. And so I looked at the bottom and it easily just popped right out. And I pulled the switch out and I looked at the part number and I looked the part number up online through Google. And I found some place that sold the part number. It was 50 cents. I got it about a week later. I literally just put it in, plugged it in, boom. And I was like, yes, I saved $500.
Right. Yeah. But here again, just in closing, Mr. Chairman, yeah, going out purchasing a new washer, a new dryer, and then a washer and Mac that was going to cost me about $4,000. This part's $150, and it's working. So
yes.
So thank you. All right, thanks, Mr. Chairman.
All right. Delegate Wilson, I'm going to assume you forgot to take your hand down.
Would assume correctly there, Mr. Chair.
All right. Is there anybody I missed then?
Yeah, I think I was on the list.
No, sir. The questions are for the delegates. I haven't gotten to any more witnesses yet. Any more questions? If not, Kevin Anderson.
Can you hear me, Mr. Chairman?
Yes, sir.
Yes, sir. I would like to thank the chairman and the committee members for my opportunity to testify today. I am Kevin Anderson, a fifth generation farmer in Somerset County. This legislation is important to me. In my operation in 2020, I spent $138,000 in repairs and maintenance. The companies I deal with have trouble finding and keeping qualified service technicians. Example number one, about 30 farmers rely on a single technician for their service needs. If he had an emergency, there would be 30 farmers without timely service. Example two, this service only has 3 technicians on staff. One is in his 70s, one is in his late 60s, and a new hire that is still in training. Example 3 has service technicians located at least an 8-hour round trip travel time to my location. With these staffing shortages and lack of resources, I am concerned about the impact this is having on my operation. In agriculture, it is critical. Failure to meet windows of opportunity have serious implications. The dealers and manufacturers are aware of the labor shortage, but have been unwilling to step outside their current structure. Dealer labor rates are well in excess of $100 an hour plus mileage and service fees. We are asking for the same rates of repair that car and commercial truck owners have right now. Could you imagine the only repair shop that could repair your vehicle is the dealer that you purchased it from? This is the current situation for ag equipment. It is only equitable that we get the same rights to repair that other manufacturers grant their customers. I have examples of these benefits of the legislation that I will share with you at the end if you're interested. I have heard a lot of misinformation that I would like to clarify. One reason for not passing this bill is deleting emissions equipment. In addition to new equipment, this bill covers equipment that was manufactured from 1996 to 2010 when there were no Tier 4 emission standards installed on the equipment. This legislation would also cover small utility equipment and gasoline engines such as lawnmowers. Safety issues concerning guidance and propulsion do not apply to implements such as planters and seeders. An example, my combine has 15 onboard computers. Only one of those computers controls the engine and emissions. Even with the concern about emissions tampering, why shouldn't I have the ability to work on the other 14? Second, my corn planter has an onboard computer with no emissions or safety concerns. Why shouldn't I have the ability to work on them? We are not asking for the right to hack or modify our equipment. We have that ability now. We are only asking to repair our equipment to the original manufacturer's specifications. Safety, reliability, and long-term useful life are paramount to us in these investments. And our investment in equipment is substantial. We are using tractors today on our farm that were manufactured in 1968. A new combine is $750,000, and a new tractor can be in excess of $250,000. These are long-term purchases, and we will be using and working on them for decades from now. You may hear testimony regarding the amount of investment that the 3 dealers I work with have in the state of Maryland. However, in their business model, they purchase Maryland companies and structured as out-of-state corporations to extract previously taxed Maryland revenues. With this bill, we are asking for the same rights to repair our equipment that the automotive and commercial truck industries are granted. We are not asking for the right equipment. The amendments offered by the ag community reflect this. I would like my technician of choice to have the same accessibility to repair my equipment as the dealer. We have waited long enough for the industry to step up and rectify this situation. The Maryland legislature has challenged Maryland farmers to be the best we can be, and I think this challenged the equipment suppliers to do the same. I urge a favorable committee report and welcome any questions.
Thank you very much, Mr. Anderson. Seeing no questions, I want to go to I want to go to the Office of the Attorney General, Steve Sakamoto-Wingle.
Thank you, Mr. Chairman, members of the committee. I'm Steve Sakamoto-Wingle on behalf of the Consumer Protection Division of the Attorney General's Office. I'm here in support of this bill, and thank you, Mr. Chairman. I'm not a delegate at this point, nor have I ever been, but I appreciate.
You're not missing much.
Yeah. Okay. I think a lot of the testimony has been covered. I did want to address a couple of points that Delegate Wilson raised early on. First, he's correct. There is no kind of licensing requirement to become an independent repair shop. Anybody can open up an independent repair shop, but that's currently the case, in the automobile repair business without this bill. So right now, Delegate Wilson could decide tomorrow, I want to, open up CT's, auto repair facility. And I might say, well, I like CT Wilson, and I trust him to repair my car, and I can bring my car there to be repaired and probably have it done, at half the price it would cost me if I took it to a dealer. And that's, part of what this bill is doing is saying, if I have, an iPhone, I don't want to have to pay the prices that Apple would charge me if I go to the Apple store. I want to be able to take it to my trusted local repair shop and have my iPhone repaired there. And hopefully, the consumer would do their homework and try to find out whether that independent repair facility is a reliable repair shop. With respect to the criminal provision in the Consumer Protection Act, yes, it is there. I've been with the Consumer Protection Division for 3 decades. I'm aware of one instance in which that provision was used, and it would only be reserved for the most egregious type of violations. I believe Delegate Wilson, in his former role as a prosecutor, would be aware of that not just, using criminal penalties for, willy-nilly. But because in that particular case, it was a home builder who raided all the consumer escrow accounts. And that's, the one instance in 30 years with the Consumer Protection Division that I'm aware of that provision has been used. So I don't think that should be a deterrent factor for making this a violation of the Consumer Protection Act. But we do believe this will benefit consumers in allowing them to select the repair facility they believe would best prepare their items at cost that is reasonable. And so with that, we would urge a favorable report. Thank you.
Any questions for the Attorney General? Delegate Wilson.
Thank you, Mr. Chair. We're going to get to the bottom of this together. I really appreciate your time. Steve, glad to corner another evil attorney so we could go over a few things, because as I laid out before, some of the law, the language in the law kind of confused me. It says about fair and reasonable terms. What exactly does that mean? It seems like a super vague statement. And again, I know that you guys don't throw people in jail often, and prosecutors, we didn't throw people in jail for weed often either. But if that was to happen, I want to make sure that we talk about, again, fair and reasonable terms in order for, like, basically, to my understanding, the exchange of the tools, software, products, schematics, and anything of that nature.
So, I mean, I believe that, one thing, it's not necessarily a defined term or something that's going to have to be subject to interpretation, through practice and through the courts, but that, a company can't say, well, if you want instructions on how to repair this particular product, I'm going to gouge you, for that. You have to make it available to the, upon similar terms, you would make it available to somebody who you have as an authorized dealer.
Could you require training?
Or
how about an NDA?
I'm not what?
How about an NDA? Training, NDA. What about a contract? Could that be considered fair and reasonable?
I mean, I think that it would require that you comply with their instructions for how to repair it if they are willing to provide you those instructions.
And if they were to do so at a cost, would that be fair and reasonable?
Yeah, I think it would be, once again, the cost of obtaining the manual on how to repair this particular product, the cost for obtaining the necessary tools and parts. And I think those are fair and reasonable terms. I don't think that you could require something that you wouldn't require of, an authorized.
And there is my final point on that, Steve. So basically, by your definition, the way you understand fair and reasonable terms, they could basically require these people to have follow the same standards to become an authorized repair provider. Is that correct?
They wouldn't necessarily have to go through all the same training, but they would have to, be able to provide them with the same knowledge, the same, parts, the same tools that would be made available to an authorized repair facility.
But they would have to at least, it would be fair and reasonable to make sure that Delegate Wilson can actually tell a front axle from a rear axle, right? I could have to pass
that unfortunately would be something the consumer would have to, be aware of, because there is no, like you said, there's no licensing standard. Now, if I wanted to, make sure that I was going to an authorized dealer, I would choose an authorized dealer. But if I want to be able to go to my independent repair shop, that's on me.
That wasn't my question, Steve. My question was about the manufacturer's requirements and what would be considered fair and reasonable. If they require you to have the same standards of training, background, knowledge, as well as equipment as an authorized repair provider, would that be considered fair and reasonable terms?
I believe that would undermine the nature of this bill, which, the intent is to make it so that somebody who's not, didn't have to go through all of the hoops that an authorized dealer had to go through, would be able to offer repairs of products.
Okay. No further questions. Thanks, bud.
Anyone else? Seeing none. Our next witness is Carrie Sheehan. Okay. Paul Roberts.
Sorry about that. I'm here. Technical difficulties. My apologies, Chairman Davis. So good afternoon, Chairman Davis, members of the committee. I am so grateful to have this opportunity to speak with you today. Thank you so much for taking the time to really focus on this bill and this issue. I work at a company called iFixit. iFixit is a free international repair guide to everything. We also help people get the parts and tools they need to repair their things. We represent a global community of fixers and repair professionals and ordinary consumers who just want to fix their cracked iPhone screen. And just last year, we helped around 1 million Marylanders learn how to fix their stuff. Now, you've had a long afternoon and I don't want to waste your time, so I'm just going to get right down to brass tacks here. This bill is about making sure that if you buy a product, you own it, you can fix it, and you can bring it to the repair professional of your choosing, just like you've always been able to do, and just like you can do with your car. I can take my car to the dealer, but I can take my car to my local repair shop, my local garage, and I often do instead of going to the dealer. Why? Dealer repairs can be very expensive. They can involve a long delay. And that's the same reason why I might go to an independent repair professional. It's common sense here. If you buy a product, you own it, you should be able to fix it, and you should be able to take it to your local repair tech. At iFixit, we've built our entire company around making sure that people have the information and the tools and parts that they need to fix their stuff, because manufacturers aren't providing this. They're not providing the information people need. They're not providing the parts that they need to fix their things. So we've tried to fill that gap to the best of our ability by helping them get access to those things. And this is relatively recent pattern for manufacturers. We've had independent repair businesses for as long as we've had stuff. For independent repair has existed from time immemorial, essentially. And we're just trying to preserve that to make sure that when you get a new device, just because it has software in it, you can still fix it. Just because it has electronics in it, you can still fix it. You can still have an independent repair business focused on fixing these devices. You can still provide jobs to your community and training to your community to help them fix these devices. Some IP arguments have been raised here. I want to mention I'm also a duly licensed attorney by the state of New York with a background in intellectual property law. And I don't want to get too into the nitty gritty, into the weeds there, but I will say that many leading experts on intellectual property law do not share the concerns that have been raised here. They support right to repair, and it's largely settled law at this point. It's definitely settled law that independent repair is not copyright infringement and it's not patent infringement, and it does not require the disclosure of trade secrets or the disclosure of source code. Nothing in this bill would impact a manufacturer's ability to enforce their intellectual property rights under the law. Nothing in this bill would require them to disclose trade secrets. And nothing here would put their intellectual property at jeopardy. But you don't have to take it from me. You all should have received a letter from law professor Aaron Krzyzanowski today, walking you through those points in more detail. So the bottom line here is that this bill is necessary for our communities. It's necessary for our small businesses. It's necessary to make sure, especially at this time during the pandemic, that people can save money, that they can save hundreds of dollars a year by repairing their devices, by keeping them running longer, and that they can access the services that they choose. I'll also say that, manufacturers don't always provide services. Authorized Service Network don't always provide the services that we need to fix our stuff. For example, I am using a 2012 MacBook Pro. Apple doesn't repair these anymore. I can't take this MacBook to Apple's authorized repair services and get this fixed. The only way I can fix it is if I go to an independent repair guy or I fix it myself. So, from our experience working with communities around the world, working with communities in Maryland, we know that there's a large need for independent repair services, and there's a large need for this kind of information access and parts and tools that this bill would require manufacturers to provide. And I'll leave it there, but I just want to also mention that I'm available for any questions and would love to continue the conversation with you, and just really committed to coming up with a solution that works for Maryland. Thank you.
Thank you very much. Are there any questions for Ms. Sheehan? Seeing none, thank you very much. Paul Roberts.
Hey, thank you very much. Can everyone hear me okay?
Yes.
Okay. Chairman Davis, Vice Chairwoman Dumais, and members of the Economic Matters Committee, thank you so much for allowing me to speak to your committee, and thank you so much for taking up this very important issue. My name is Paul Roberts, and I'm the founder of SecureRepairs.org, and editor-in-chief at a publication called The Security Ledger. We're a cybersecurity news website, and I'm speaking here today to express my support for HB 84. And the first thing I want you to know, just before anything else, is about my group, SecureRepairs.org. We are a group of more than 200 of the country's top information technology and information security professionals who support a digital right to repair. You're going to hear a lot of arguments from industry lobbyists, manufacturers, and their lawyers and their PR agencies about cybersecurity risk with connected devices. And what I would like you to do is just when you hear those, think like, oh, that guy Roberts talked to us, and he had that group of security experts who support right to repair. I want you to keep us in mind, and I want you to, my testimony has been submitted in written form as well. My contact information is on there, and I want you to reach out to me so that I can connect you with an actual information security expert to tell you the real truth about connected device security. And what you're going to hear today is that, you know, there is no cybersecurity risk to repair. That this bill is really, as Kerry and others and Owen have said, is about empowering owners of devices and small businesses, small business owners, entrepreneurs to say, I'm good at fixing things. I'm good at fixing toasters and dishwashers and washing machines. I want to set up a business and do this for my neighbors, or I want to do it for myself as an owner to save myself hundreds of dollars and to prevent, you know, taking a perfectly good device and throwing it in a landfill just because I'm unable to fix it. That's what this bill is about. The cybersecurity arguments are what we call in cybersecurity industry FUD, fear, uncertainty, and doubt, designed to scare you away from supporting this bill with more or less empty arguments about cybersecurity risk. I'll tell you one thing. We know that there is not a cybersecurity risk to repair because in this country, there is no digital right to repair, but there is a huge cybersecurity issue around connected devices like webcams, routers, and other connected appliances. It exists without any right to repair. ESET had an article in October, 50,000 connected webcams exposed and on the internet. Hackers could go in and view people's homes. These stories come up, home routers taken over by botnets and used to launch attacks. These stories show up in our newsfeed every day. They are completely independent of any repair issue. This has to do with poorly designed, deployed, and supported products by the same manufacturers who are coming to you and telling you that this bill is too big of a cybersecurity risk. Simply do not believe them. There is no truth to what they're saying. And in fact, their promises and assurances that the security of their products and their customers' data are their top priority, frankly, the record is against them on that. That is clearly not the case. I would ask you and Delegate Wilson and others, as you hear about the excellent repair that's authorized service providers provide and the terrible quality repair that you're going to get from an independent or from an owner, I would ask you for empirical data that shows that there's any superior outcomes from independent repair or authorized repair. All of you know this because you own automobiles. And if I had to guess, you bought your car new, took it to the dealership when it was under warranty, and then the minute it wasn't under warranty, you went to the corner repair shop. Okay, the dealership would have told you, oh, don't, get the timing belt replaced with us. That independent repair guy uses crappy parts and he doesn't know what he's doing. But you went to the independent repair guy anyway. And let me guess, the repair was great. The parts were fine. You saved yourself $400. That's what this is about. In conclusion, let me just say this. This is one of the few issues that you're going to encounter that is pro-consumer, pro-free market, and pro-environment, okay? You're not gonna see those three line up on many issues. This is one of them. And in a world that we're entering with internet-connected software-powered objects, the so-called Internet of Things, Digital right to repair is a vital tool to extend the life of electronic devices, ensure their safety, ensure their security and integrity. We all want to benefit from new connected products with cool features, but the price of those features for the public cannot be a monopoly on aftermarket parts and service. That is too high a cost to pay. And I urge you to support this bill, to support the small business owners of Maryland, not the multi-billion-dollar corporations like Apple in Cupertino, California, and pass this bill out of your committee. Thank you very much.
All right, thank you, Mr. Roberts. Questions for Mr. Robert? I see Delegate Wilson has his hand up.
Delegate Wilson, you're on mute.
Maybe this is why I have problems with this bill. I can understand technology. First question, Mr. Roberts, you're talking about warranty or independent contractors versus authorized. Is it your understanding if this bill passes that will that change the way the warranties work as far as whether if you, because I know if an authorized repair person fixes my phone or my MacBook, that it's still under warranty. Is it your understanding that if an independent contractor
Yes, of course. The Magnuson Warranty Act is very clear, Delegate, and it makes clear that you do not void the warranty by repairing it yourself or by taking it to a non-authorized repair person. You believe that because manufacturers spend a fair amount of marketing dollars to create the impression that that limitation existed by putting void if under warranty. FTC has gone out to manufacturers in the last 5 or 6 years and specifically told them that they are in violation of the Magnuson Warranty Act for putting those stickers on their products. That limitation does not exist. It never existed. And the reason that we're hearing that argument there is that the marketing and PR dollars of the manufacturers serve them quite well.
Well, and that I knew you were going to have an answer, but that wasn't my entire question. Give me a second. If you go to an authorized dealer or repair person and they mess up something, the warranty will still protect it. If you go to an independent repair person and they mess up something,
yes, it will.
So if I repair my phone and I break the glass or I do something, you're telling me my warranty is still covered for what I broke.
Well, it depends on the terms of the warranty, of course, Delegate. But yes, the terms of if you're assuming you don't violate the terms of the warranty, then the warranty still applies. Yeah.
So by your logic, Apple has to repair something that I break on my phone because I tried to fix it.
Well, no. if your product is under warranty and the nature of if your Apple phone is under warranty, okay, and you bring it to a repair person, or the phone breaks when it's under warranty, the warranty still applies, right?
But if I fix it and I break something trying to fix it, Apple doesn't have to cover that. But an authorized repair person, if they break it when they fix it, it's still under warranty. Their repairs are still under warranty.
See, Delegate Wilson, this is an argument that, again, manufacturers have invested some significant resources in creating the impression that you only get the warranty if you go to their authorized repair. It simply is not true. That's not how the Magnuson Warranty Act works.
You said that. I get it. What are
you asking? I'm not sure what you're asking.
I was specifically asking that if an independent repair person breaks a phone, any damage is done is not covered by any warranty. Whereas if an authorized repair person damages your phone by mistake, no.
We take this risk every time we go to an independent auto shop or any person who does work for us. There is the possibility that they'll do crappy work, and that we'll have an issue with that person as an individual, as an entrepreneur, as a business person. That's how the market works. If they do crap work, they're going to lose business and go out of business. But we all benefit from having the market and the competition, not just Apple's authorized providers, but a wide range of independent providers who do the work for less. Well, and that's what this bill is about.
I've gotten your point from the beginning. If I take my Tesla to my buddy's house and he fixes something and breaks it, Tesla doesn't have to cover that under my warranty. I have to take it to a Tesla or an authorized Tesla repair person. That was my only point about the warranty. We'll agree to disagree, apparently.
The terms of the warranty says what it says, and
I know that.
obviously you can't just do anything you want with your device and expect Apple to pay for it. Right.
That's where we are, which you can and can do.
Apple's got $200 billion in cash in the bank, so somehow I think that they're doing okay.
And I wanted to ask you the second question about the cybersecurity, because you brought up a very good point. And again, these are not gotcha questions because I don't know the answer, which is why I'm asking.
That's why I'm here.
Thank you very much. The issue I had with cybersecurity really boils down to if all this stuff is released, if I take my wife's phone, I can get them to download everything on that phone at a repair shop, right?
No. So, let's take smartphones because they're the electronic product we're most familiar with.
That's the one my wife uses. That's one I'd be getting.
Right. So it really depends on the repair that they're doing. But in general, mechanical repairs shouldn't necessarily require you to log into the phone. So if your wife took your wife's phone to a repair shop and it was locked with her Touch ID or her face, they shouldn't need to open it in order to replace a screen or to fix a discrete part. Now, there may be potentially a repair where they do need to do that. And the independent repair person or the authorized repair person would, of course, have to ask your wife's permission to do that. And that is an issue of trust. I would tell you that if you go through the police reports and so on, there of course have been issues of unscrupulous repair people taking pictures and data and so on off of phones, particularly pictures for obvious reasons, right? I would tell you that those are both authorized and unauthorized repair persons. There is no evidence that the guys at the authorized place are PhDs with lab coats and the other guys are, criminals and never-do-wells. They're the same people working for different organizations.
My only worry was the cybersecurity, and I will be done in just a second, Madam Vice Chair, was the more people that have keys to a lock, the better chance there is or opportunity there is for some problems to occur. That's truly my concern.
Any repair that we do requires us to extend trust. If you have a dishwasher repair person come to your house, you're inviting them into your home. They could take money out of off your countertop. They could, help themselves with some other piece of property in your house. That's an inherent risk in the act of repair. The advantage is you get that professional come to your house and do the repair. And so you need to extend, some trust to them to do that. And that's true with electronic devices, of course, as well. It's just data as opposed to physical access.
Just one final question, ma'am. Would you, I was talking to Madam Vice Chair.
I knew who he meant.
I was asking her permission to give one more question.
One more.
Trying to find a way, because I'm asking these questions. I'm trying to way. I heard the farmer talk. I'm hearing these people talk. I'm trying to find a middle ground. Is there any way, would you think of where a time limit is placed, like 3 years, and then everything has to be released versus a brand new iPhone 12 or 20, whatever they're on now, meaning after a certain period of time, this stuff gets released. After 3 years, all this stuff has to be released. Is that remotely doable from with what we're talking about? To put that 3 years in there and say, after this, you don't have anything to talk about. Or after 5 years, you can't say source code anymore because it's changed so much.
Are you asking me or are you asking?
Yes, sir. I'm sorry. Yeah.
No, it's just you.
Just
okay.
you, buddy.
Could you just repeat the question one more time, Delegate? Sorry.
I was asking if we set a time limit of like, say, 3 years or 5 years for this bill to take effect, meaning after a product is 3 years on the market, then Apple has nothing to say about source code or security, and all that stuff has to be released for the generalized repairs or for these repairs versus right off the bat. Would that be something that you think would get this ball rolling?
Well, first of all, let me just clarify, Apple doesn't ship source code on their phone.
I know, I was just using
but I would say the 3 year, no, reality is, well, first of all, when most people are buying new electronics, let's take an Apple phone, there is, a warranty period of a year anyway. But no, I would say that what you're proposing is kind of a lock-in period for the OEMs to have exclusive rights to aftermarket service and repair. And I don't think 3 years makes sense. I don't think any time period makes sense. there may be reasons, given the circumstances of how you bought it, that you're gonna, you bought the Apple Care program or something, and you're gonna bring it to Apple because you have that premium repair program. But I don't think you want to enforce that on consumers, because that's going to be an added cost to them, right? If the manufacturer says, I've got a 3-year lock-in on service, what can they charge for that service? Whatever they want.
But aren't we locking them in like forever now?
No, you're saying we're going to advertise the tools and the information, schematics, diagrams.
I meant before the bill passed, sir. If the bill doesn't pass, aren't they locked in forever instead of 3 years?
If the bill doesn't, the bill is standardizing a set of business practices.
I know.
To enable a diverse ecosystem of service and repair. Right now, that does not exist, and so companies like Apple or Samsung or John Deere can use discriminatory practices to lock out competitors, and this bill would remove those.
Right, and I'm just asking, but if we had a 3-year lockout period and say after, because right now it's a total lockout period from what I've heard. If we said after 3 years, Apple no longer has an argument about their product and protecting their product, would that be something that would get this along the line of what you're trying to do?
I'm going to punt that to others like Nathan.
Okay.
All right, we're going to go. I think we're going to move on. Thank you very much, Mr. Roberts. Delegate Chi.
Thank you, Madam Chair.
The only thing, if I can remind the committee, we have about 13 more witnesses.
Okay, thank you. I really was just trying to understand for my own sake. I appreciate very much the spirit of this bill to make it more accessible and affordable for consumers. I guess my question and curiosity is, so far the discussion I have heard has mostly focused on the assumption that we're talking about the global giants that own the intellectual properties and technologies that would impede on local small businesses' abilities to repair. Can you help me understand, and the questions could be to either the bill sponsor or Mr. Roberts or whoever can chime in. Can you help me understand what if we're talking about local small businesses or much smaller businesses that also own their intellectual properties and manufacture, make their own products? How would that be different from like Apple's of the kind?
I think Kerry's probably best fit to answer this question.
Thanks, Paul. Thank you, Delegate.
All right.
I just
want to allow this, but this isn't supposed to be a group effort.
Oh gosh, I'm sorry. I'm happy to.
My fault.
It's okay. Go ahead. I think you probably are best. So why don't you go ahead?
Thank you. So I appreciate that. So I just wanted to say, even small businesses, are not at risk here, right? Small businesses still have the rights they have under federal intellectual property laws to sue for intellectual property infringements, and in some cases pursue criminal penalties if any intellectual property infringements happen, right? So they already have the full list of remedies that copyright law, patent law, trade secret law provides them, and this bill doesn't change that at all. So they'll still have that ability. They'll still have those resources, and this bill does not require them to put their intellectual property at risk. So it does not require the disclosure of trade secrets. It does not require the disclosure of source code, the code for the software. It doesn't require them to make that available. And it doesn't require them to make available anything that they're not already sharing with their broad networks of authorized service providers. And so I just wanted to kind of clear that up and make sure that you understand that it's not about big companies necessarily versus little guys. It's about consumers having the right to repair the products that they own and to choose the repair businesses that they want to patronize.
Okay.
Thank you.
Thank you very much. Any other questions for Mr. Roberts? We're going to move on to the next witness, Samuel Mensimore. I'm sure I mispronounced your name and I apologize. But
you're good. You were close, Mensimer. Okay. Hello. My name is Sam Mensimer. I'm 17. I've been running a business fixing electronics since I was 12. I was here last year testifying in front of, I believe, the same committee 3 days before we stopped going to school for good. I'm never going back personally. I'm graduating. I'm here because I think right to repair is an incredibly important issue, and now it's become even more of an important issue. When people started working from home, work started revolving around electronics. Every kid needed a computer to go to school. And it's also completely changed how people see the importance of independent repair shops. People like me kept people's electronics working while Apple closed all their stores in like March, April, May. I'm not really sure how long, but it was quite a while. And they were quoting about like 4 to 8 week turnaround times for mail-in repairs. So I was fixing people's devices that were under warranty because these people couldn't wait 4 to 8 weeks for Apple to fix their stuff. And it's not just Apple. Right now, school is all online. So the demand for like school issued Chromebooks has pretty much gone through the roof. So it also means that the demand for repairs on school issued Chromebooks has gone through the roof. This right here is a stack of Chromebook motherboards from some school districts in Long Island, New York. My job is to fix them because Acer will not sell replacement parts for them. So there's no documentation available for them. So I have to use what I have here to basically reverse engineer these things and try to figure out how second graders manage to break them in every way I could possibly, or things I'd never thought were possible. But this stack of boards is also unfixable because Google, who makes the embedded firmware in these boards, does not make the software available to the public to reprogram this one little chip on this board that is paired. So this stack of boards is going to go into a bin in my shop here and go into the e-waste pile. And this school is going to have to buy however many new Chromebooks there are in this pile. So right to repair would mean that I could reprogram that chip. It doesn't mean that I'm asking for source code. It doesn't mean that I'm asking for like any way to crack whatever security Google has built into this. I just want to be able to swap out parts on these computers and have them work again. So it would also enable me to stop turning away repairs from people who desperately need their stuff, like their electronics for work. And it would cut down on toxic waste, like this giant pile of boards that's going to go into a trash bin. And it would support small businesses like myself who repair everybody's electronics. So I urge a favorable report on this bill, and I thank you for your time, and I'll happy to answer any questions.
Thank you very much. Any questions for Mr. Mesmer? Delegate Walker, sorry, I'm looking right at you.
Thank you, Madam Vice Chair. This may be for the sponsor, or maybe the gentleman just spoke. Are there other states that have taken up this this type of legislation?
Taken up this type of legislation, as in passed it, or?
Yes.
I don't think any of them have passed it so far, but there are, I believe off the top of my head, there were about 14 that are considering it.
Okay, and Delegate Wilson, you may be able, if you're there. This seems like something that should be dealt with like by the court system, almost like by the Supreme Court or something like that. It almost seems above our grade here, what we're trying to do, whether it's right or not right.
Thank you very much, Delegate Walker. Any other questions for Mr. Mensmer? All right, thank you very much, and thank you for your testimony and coming in today. Next, Colby Ferguson.
Thank you, Madam Vice Chair, members of the committee. Colby Ferguson here on behalf of Maryland Farm Bureau, and we come in support of House Bill 84, also with some clarifying amendments to try to address some of the safety, durability, environmental, and liability reasons. I wanted to kind of just go with what Mr. Anderson talked about earlier. You know, this is a very all-encompassing bill and really gets into a lot of different areas and sections of our society, and really the area that we're coming in is really on the farm equipment side, and you know, we worked very, very closely with the farm equipment dealers in 2020, even through the challenges of COVID and having to do everything virtually, and honestly, they have done a lot of really good information and provided a lot of really, really good things to really help you and help a farmer diagnose and figure out what's wrong with that piece of equipment, and get to the point where you can order that part, you can install that part yourself, And really what it comes down to, the sticking point, and the last gentleman that testified brought up about the same problem that we're having is that we find that repair part, we put that part in, and the last little segment needs to turn that piece of equipment back on is pairing that part back to the motherboard or back into that computer, or what we call flashing the system. And right now that is not made available to farmers or to independent repair in the equipment side. And so really when it comes right down to it, I can fix anything on my tractor right now if I had the working knowledge to do it, except for when I tie it into that computer, and that computer can't read that brand new part because it's just a standard part and it needs to be paired with the system. I have to call a technician to come out and do that flashing of that software, and that cost right there, if the technician can be there on time, is a major component, especially during the busy time of the year, and it's very costly as well. So really what we're asking for is to have that ability to pair that part and flash that together. And honestly, the way the new equipment's coming out, they're starting to tie the new models that are coming are even less repairable than the previous models. They're now starting to include the proprietary interfaces for attachments. So if I try to attach a no-till drill or a piece of equipment behind with multi-use components that tie back to the main computer in the tractor, a lot of those pieces are proprietary, and you can't even repair that, even if you have the parts and you own the equipment, not just a lease. So there are some clarifying amendments. I think it's probably in Mr. Anderson's written testimony. I just emailed you all my written testimony individually because I didn't have time to get it in back on Monday as we were clarifying it. But really, it just gets down to trying to address a lot of that right to tamper issues that a lot of the dealers have. And I think it really cleans up a lot of that mess. So we would ask for a favorable report with these amendments. Thank you.
Thank you very much, Mr. Ferguson. Delegate Motz.
Thanks. I'll make it quick. So, last year this legislation came up, and John Deere came in and testified against it. Were we able to see their testimony last year? Colby, can you hear me okay?
Yeah, I can hear you. My guess is they did, and my guess is they submitted written opposition to it again this year. We worked with John Deere, and they're, they've gone a lot farther than Apple and some of these other industries have, as far as really giving you the opportunity to fix your equipment. But it really comes down to that last mile issue of I need to be able to, I can plug it all in, I can purchase it, I can do it all myself. But when it comes down to pairing that new part to the motherboard, I'm not allowed to do it. So that's what we're asking.
Kind of caught me off guard there. I was checking out your screen in the background, and it looks like you got big red back there, but that's a screensaver, isn't it, behind you?
Yeah, I wanted to make sure I came. This virtual thing is can make you get pretty creative sometimes.
That's an International Harvester.
It's probably a Case International, yeah.
Yeah. So they got international. What are the major implement producers? You got Atlantic. You got John Deere, Case, and International, and I'm sure I'm missing a couple, right?
Yeah, the main ones. You've hit the main ones there. You have New Holland, Kubota on the farm equipment side, but yeah, the distributors are in the John Deere side, as well as the Case IH and equipment dealers like that.
Because they're pretty incredible right now. Like, you can tell how many bushels of yield you're pulling when you turn a corner in some of these different machines, can't you?
Yeah, everything's electronic now. I mean, grandfather's old tractor that you could tear apart and put right back together and repaint and do all that is one thing. But today, it's all run on computers, which that technology is, allows you to be sitting in the tractor and set a computer through GPS, and that thing will drive itself, and it'll precision agriculture is what we got. And so technology is a double-edged sword. It's absolutely essential to do the jobs that we need to do, but at the same time, it's almost impossible to fix unless you're an authorized dealer.
Yeah, and that technology is kind of what's driven us to where we are. We need it, but at the same time, you need it. But in order to invest the money into it, are you concerned at all that if this were to become law, that some of the manufacturers would just say they would just start working, their drive to come up with the newest, greatest technology would kind of go to the wayside because they know they can't one up the next guy?
I don't think that. I do believe that the service side of the dealer is very critical to their business plan and is essential and needs to be maintained. Where I see the challenge, or what I see what this would do is, myself personally, I'm not going to try to fix my own tractor. I'm going to call my Kubota dealer that's 3.5 miles from my house, and I'm going to have him fix my tractor because, number one, I don't have time, and number two, I don't know how, and I don't want to find that out. So the vast majority of the farmers are going to fall into that same platform. But when there's an opportunity that you have worked on that piece of equipment, you maybe even were part of the test subject to determine how that new piece of equipment was created, you know how to fix that piece, you ought to be able to have the ability to fix that and not have to call a technician to come out and push start.
Yeah, because I always try to stand up and do what I can to help Farm Bureau and agriculture, but this may be one where I may not be there for them. It's an intersection of property right versus, we're at a tense moment. We were talking earlier, there was some testimony about trade secret, and the testimony was, when I buy that product, I own it, I own everything about it. And that was just flat wrong. I think the great example for trade secret is Coca-Cola. And I mean, that's changed now with digital products, but you buy a Coca-Cola and you look on the ingredients on the back, still there's a trade secret for Coca-Cola, and that's the seminal concept of trade secret, and it's under lock and key, hidden somewhere, I think in Atlanta, Georgia. But I appreciate you testifying, and I'm gonna look at it and try to talk to you and do whatever I can to help. I just, it's a tough spot, but thank you for being there, and it's a good looking tractor you got behind you.
Thank you, Delegate Mounts, and I would conclude with saying that you're making the exact same argument that was made by the auto dealers before they were required to do the same thing.
Okay. All right, thank you very much. I think that's all the questions, and that concludes the proponent's testimony. We will now move to the opponents of the bill, and we'll start with Lisa McCabe. Lisa McCabe here. I can't see her on the screen, but
let me.
All right.
Sorry, I'm here.
Oh, sorry. Go ahead. I didn't see you.
Oh, okay.
Okay, you're on.
Chair, members of the committee, my name is Lisa McCabe, and I'm here on behalf of CTIA, the Trade Association for the Wireless Communications Industry, in opposition to HB 84. The marketplace already provides a wide range of consumer choice for electronic product repair without the mandates imposed by this legislation. For example, manufacturers have relationships with authorized repair providers, as we've talked about. These providers, which include local and small businesses, have received the appropriate training from the manufacturers and have the qualifications to make sure that repairs are done properly and safely. Manufacturers have gone to great lengths to produce products of the highest quality, and authorized repair ensures that those products maintain that high quality and guarantees that repairs meet manufacturer standards. In addition to authorized repair, manufacturers offer walk-in repair at retail, as well as mail-in services. And insurance providers offer repair, which may even include a third-party remote technician traveling to the consumer to perform a repair. Consumers can currently use independent repair today, although manufacturers cannot guarantee the quality assurance of independent repair providers. We're concerned that this legislation would have a number of unintended consequences for the operation of electronic devices. For example, even if an independent repairer is provided the technical information required under this bill, without specific training on reassembling a device, they could unintentionally cause antenna performance problems, which could make it so an important call doesn't go through, or put stress on the device's frame, which could make it break more easily when dropped. For these reasons, we respectfully urge an unfavorable report on HB 84. Thank you.
Thank you very much. Any questions for Ms. McCabe? All right. Thank you for your testimony and for being here today and your patience. We will move to John Keene.
Hello. Yeah.
Here we go.
Good afternoon, members of the committee. My name is John Keene, Association of Home Appliance Manufacturers, and we are in opposition of House Bill 84. Safety is a top priority to manufacturing. This bill raises serious safety concerns. One thing to keep in mind for our industry is the fact that technicians enter the private home of consumers, and therefore safety and security take on additional meanings. Also, our products contain sophisticated and highly advanced operating systems, as well as intricate chemical compositions. In fact, appliances are subject to electrical codes, building codes, and plumbing codes. That is why it's paramount to have an authorized repair professional who can handle such things as refrigerant gases, wiring, electrical connections. If manufacturers are required to make their technical information public knowledge, they no longer have the ability to properly assess whether the technician entering the homes of the consumer have met the necessary technical, safety, and security check to keep the customer safe. And finally, I do want to mention that there's currently a nationwide home appliance service and repair network that includes over 20,000 servicers and repair shops that are authorized in the United States. Of the 20,000, roughly 88% of them are local independent brand manufacturer affiliated. Only 12% of those are manufacturer branded in-house services. So there is a pathway currently to become authorized. As I said earlier, authorization is so important with our products because anything wrong with our products can lead to potential property or consumer danger. And with that, I strongly urge you to provide unfavorable report for House Bill 84. Thank you so much.
Thank you very much for your testimony. Any questions for Mr. Keene? Seeing none, we will move on to Dusty Brighton. Again, I can't see you on my screen. Is Dusty
Madam
Brighton?
Chair.
There we go. Sorry. All right.
Thank you, Madam Vice Chair. Appreciate it. Hi. I'm here on behalf of the Repair Done Right Coalition. The Repair Done Right Coalition is made up of companies, organizations, and people who care about ensuring that their innovative products are repaired and maintained in an authorized manner. Many of the reference companies began in places such as Maryland. These companies assisted in connecting consumers, businesses, and governments through products that are designed to assist in improving the lives of those who use them. During the pandemic, products and services manufactured by these companies that I referenced have been essential in ensuring commerce and personal relationships remain intact. We did submit a letter, so I'll keep this short. Letter dated January 22nd. The bottom line is that many equipment manufacturers offer consumers a wide range of safe and secure repair options through their authorized repair networks. Most consumer technology products are comprised of complex electronics, which require the specialized training that it will take to repair a product if it is damaged. Also, there are safety issues. The products have lithium-ion batteries and really should only be handled by trained professionals, as there are safety hazards with that. Manufacturers just want to ensure that their products are serviced by professionals who understand the intricacies and also adhere to the standards of quality repair that they institute. So as someone mentioned earlier, there have been 20 state legislatures that have reviewed similar legislation, and none of these bills have passed yet. There's a reason for that. So glad to talk further. We appreciate the opportunity to be here today, and on behalf of the Repair Done Right Coalition, thank you for your time.
Thank you for your testimony. Delegate Charkoudian has a question.
Thank you, Madam Chair.
Mr. Britton, thanks for being here. Can you tell me more about the Repair Done Right Coalition? Can you give us some examples of some of the members and the funders of the organization?
Sure. A lot of the companies that have been mentioned here today, mobile telephone manufacturers, as well as laptop manufacturers. And then some of our coalition members have testified here today. John Keene with AHAM, Lisa McCabe with CTIA. Those are some examples.
Do you think it's possible that the reason that the bill hasn't passed in the other 20 states is not because it's good policy, but rather because those companies have such influence on legislatures?
I'm sorry, what was the last sentence?
The implication that it hasn't passed in other states because it's not good policy. And I'm just wondering if it's that it's not good policy or just that those companies have more influence on those other legislatures.
Well, I think it's probably because of the implications of the policy. Of course, these member companies, as well as the Repair Done Right Coalition, are going to argue when there's something that they look at that threatens consumers and as well as the well-being company.
Sure, they're businesses. I understand that. That's your job. So let me ask another question. Are you familiar with? I'm not. This is actually a genuine question. With a process when was there a shift when car manufacturers used to be able to control who had access to the information to repair cars, and was there a shift to the model that we have now that allows for this wide range of independent car repair shops? Do you know anything about the history of that shift?
I do not. I have to admit, I don't know that. I'd be glad to get back to you on that. I do know, as a personal example, I had an automobile that had a problem. I took it to an unauthorized repair shop and ended up spending a lot more money getting it fixed by an authorized repair shop later. And of course,
you only ever take your car to the dealer?
No, it just depends on the issue. Sometimes I'll take it to another provider, but if it's something to do, I will say if it's got something to do with computer software, something like that, I'm probably taking it to an authorized dealer. Yes, ma'am.
So as a consumer, it sounds like you value that choice to be able to make the decision about when you're going to a dealer and when you're going to somebody in your community who has a great deal of skill and that you trust. But you get to make that choice. Is that right?
Yes, ma'am. And I would say that there are a lot of authorized repair dealers out there. I feel like consumers do have choice. The coalition feels like they do have choice. Anybody can become authorized. They just need the proper training.
Restricted by the manufacturers. But I think I would be interested in understanding more about we think that things get stuck in the way that they are, often in a way that is, in this case, potentially bad for consumers, bad for farmers, bad for small business, bad for the environment. And we just kind of continue that way because, somebody has to move first, some state has to move first. And I think it might be instructive to look at if there was a time when car manufacturers controlled the repair in the same way that the manufacturers we're talking about now control the repair, and how that shift happened, because I think that we all do accept the current structure for car and car repair. And it's instructive for us to get out of the place that we're stuck right now, which really isn't working for a lot of reasons. So thank you very much for your time.
Madam Vice Chair.
Yes, Delegate Adams.
Thank you. And unfortunately, Dustin, you're the receiving end of a question I wasn't going to ask, but have you ever contacted my office about this bill?
No, sir, I have not personally.
Okay, first off, I'll speak for myself on this and say I don't get influenced by anyone other than my own sensibilities when I read a bill, read a fiscal note. The problems what I have with the bill is it's broad, it's worded in a way that's not easy to enforce, and it throws the Consumer Protection Act in the face of the businesses. And those are my frustrations with the bill. Would you agree or disagree with that?
I would say that there are implications as it is currently written with regard to the Consumer Protection Act, which obviously they've been discussed here today. Yes,
Because
sir.
the problem with this bill is we're talking about cell phones, and all of a sudden we're also talking about, you know, a 3 or 4 ton combine and the safety related to running mechanical equipment. At the same time, we're talking about a disposable consumer device that's harmless. And so that's just one example. But I take offense to the idea that legislatures get influenced over something like this, and we aren't free thinkers when it comes to policy making. Thank you, Madam Vice Chair.
Isn't that so? That was a question. I'm teasing. Okay, any other questions for Mr. Brighton? Delegate Wilson.
Thank you, Madam Vice Chair. And I'm sorry, Mr. Brighton. I just because I was waiting, that caught me off guard too. Have we spoken before?
No, sir, we have not.
And again, I don't know who you
But
represent.
I'm glad to correct it.
No, that's fine. But who you represent again?
The Repair Done Right Coalition.
Right. Okay. Yeah, I just wanted to make it clear that we have never spoken before. I didn't know who you represented. All the problems I saw in the bill, I used this tiny pea up in this brain to identify, because I did go to law school. So I do take slight offense that things don't move forward because we're so gullible. Thank you.
All right, thank you. Any other questions for Mr. Brighton? Thank you, Mr. Brighton, for being here today. We'll move on to Alan Schaefer.
Great, thank you very much, Madam Vice Chair Dumais and members of the committee. My name is Alan Schaefer, and I'm the Executive Director of the Diesel Technology Forum. We're a not-for-profit educational group headquartered here in Frederick, Maryland, established in 2000. We represent manufacturers of diesel engines and equipment, components, petroleum and renewable biofuel producers, and a list of our members is attached to my written statement. Over the last 2 decades, the DTF has been an active participant and a consistent supporter of efforts to reduce in-use diesel emissions here in Maryland. I'm here today in opposition to House Bill 84 because, if enacted, it has the potential to make Maryland's air dirtier, not cleaner, to jeopardize heavy equipment safety for both farmers, vehicle service technicians, and the general public that share the roads, and finally facilitate a practice that is in violation of the Federal Clean Air Act. Diesel engines and fuel power nearly all farm tractors and machines, thanks to the unique combination of efficiency, power, durability, and reliability. Over the last 2 decades, manufacturers of diesel engines and equipment have invested billions of dollars to reduce emissions and meet federal clean air requirements. As a result, today's new models of everything from highway tractor trailers to construction machines, workboats, and farm tractors now achieve near zero emissions for both nitrogen oxides and particulate matter, as you can see from the attached chart in my written testimony. These advances in lower emissions are a key part of Maryland's Clean Air Plan and achieving the national ambient air quality standards here in our state. Achieving these near zero emissions in the engines is accomplished thanks to a highly integrated system controlled by engine control units, computers, ensuring on a real-time basis that the engine performance of the machine is meeting the EPA emission standards and is also in compliance with the safety requirements, while also meeting the performance demands of the customer. This legislation seeks to legitimize and facilitate the modifying of farm equipment software, being sold as boosting performance for pennies on the dollar compared to the high cost of buying new equipment. This practice, in fact, might void the equipment's warranty along with insurance agreements and is illegal in the US relative to the Clean Air Act. That Clean Air Act requires equipment manufacturers to build in base level tampering safeguards and emission control units and engine computers. Restricting access to software that defines the machine's emissions performance is part of these base level tampering safeguards put in place to meet the requirements of the Act. A new development since I appeared before this committee last March is that the US EPA Air Enforcement Division, AED, released a substantial report in November of 2020 regarding the incidence of tampering with diesel engines and emissions controls. Based on their enforcement action against a variety of repair shops and parts vendors, they identified substantial vehicles that had software modifications to their engine emissions control units. As a result, EPA's Enforcement Division estimates that the emissions controls have been removed from more than 550,000 diesel pickup trucks nationwide in the last decade. As a result of this tampering, more than 570,000 tons of excess nitrogen oxides emissions and 5,000 tons of excess particulate matter will be emitted by these tampered trucks over the lifetime of the vehicles. Now, this report did not quantify the extent of tampering in off-road engines and equipment, but it notes, and I quote, AED has reason to believe that this conduct occurs within most or all categories of vehicles and engines, including commercial trucks, passenger vehicles, pickup trucks, motorcycles, forestry equipment, and agricultural equipment, end quote. Beyond the increased emissions of NOx from modifications to the engine control unit under the right to repair legislation, HB 84, that will make Maryland's ozone non-attainment status worse and increase NOx deposits in the Chesapeake Bay, we're also concerned with the safety and reliability and durability issues that could be caused by changes to other machine functions that are controlled by software. Manufacturers are also implementing plans to facilitate more access to tools and documentation needed for repairs. Modifying engine computers, though, to boost performance can result in higher operating and exhaust temperatures, overheating, accelerated wear and stress on high-speed parts like power takeoffs, hydraulics, and belt-driven systems. And there are a number of documented cases of personal injury from tractors and machines where unauthorized engine programming modifications were made, and yet these might not be obvious to others who may acquire that equipment, operate that equipment, or go to repair that equipment themselves later. So for all these reasons and others, we urge your vote in opposition to HB 84, because so-called right to repair legislation really takes us the wrong way for clean air and the wrong way on safety. Thank you for the opportunity to appear here today.
Thank you for your testimony, Mr. Schaefer. Any questions? Delegate Wilson, is your hand up because you forgot to put it down?
Somebody forgot to put it down, Madam Vice
Okay,
Chair.
that's all right. Anyone else have a question? All right, thank you, Mr. Schaefer. We will move on to Daniel Moyer. Daniel Moyer, I don't see him.
Can you hear me now?
Oh, sorry, there he is. Okay.
Sorry, technical difficulties. Madam Vice Chair, members of the committee, my name is Dan Moyer. I am with the Consumer Association. Appreciate the opportunity to speak in opposition to House Bill 84 today. CTA is trade association representing more than 2,000 manufacturers and retailers of electronic equipment in North America, and many of whom are concerned with the unintended consequences of this legislation. We've submitted written testimony, so I won't go over the details. I'd just like to echo the concerns that have been outlined already in terms of consumer safety, privacy, and security. My background at CTA is in environmental policy, so I'd like to touch on some of the environmental and sustainability arguments espoused by the proponents of this legislation. They're arguing that allowing unauthorized repair providers access to this diagnostics and tools would prevent a lot of devices from being chucked into landfills. And unfortunately, this is just a mischaracterization of the e-waste situation, both in Maryland and the United States. Our written testimony has a lot more data I'll direct you to, but we've cited sources from both the EPA and academics at Yale and RIT showing that electronics are actually the fastest declining portion of the municipal solid waste stream. And our own CTA research on consumers shows that particularly when it comes to mobile devices like these, most consumers don't throw them away in the bin. What they do is they trade them in or they recycle them responsibly. There's still a lot of value in a lot of electronic devices. So a lot of times they don't end up in the trash and they're actually either passed on to another person or traded in for value when you upgrade to a new device. A lot of our members already have robust, responsible e-waste programs to make sure these devices are handled responsibly. And then if they can be refurbished, they will be done so at authorized repair providers. So in short, my argument is just that given the extreme weight of the concerns about privacy, security for consumers, the negligible environmental benefits of this legislation shouldn't come the way against it. So I'd urge an unfavorable report, and happy to take any questions or talk offline about the sustainability implications of this legislation.
Thank you, Mr. Moyer. Any questions for Mr. Moyer? Seeing none, thank you very much, and thank you for your patience today. Next, Tim Lambert.
All right, can you hear me okay?
Yes.
All right, good afternoon, members of the committee. My name is Tim Lambert, and I've held various service roles for the Carter Machinery Organization over my 26-year career. Carter Machinery is the Caterpillar dealer serving the state of Maryland. We operate over 14 locations in the state with approximately 400 employees. we are strongly opposed to the passage of House Bill 84. Caterpillar customers are already given access to many software codes to help them repair their equipment. They can access logged diagnostic codes, perform diagnostic tests and calibrations, and monitor their equipment performance in real time. We draw the line, however, at providing access to embedded codes that control the safety and federal EPA emissions compliance on the equipment. Given access, they could manipulate the coding to disengage built-in safety features of the machine, such as safety levers on excavators, seat sensors, overload sensors, etc. We are concerned that access to such codes will invite the tampering of complex engine and hydraulic systems operating near the public. Our power generators also serve as critical backup to hospitals, data centers, and local and state government buildings, and providing access to unqualified personnel could pose a risk to the occupants of those buildings. At Carter Machinery, we invest hundreds of thousands of dollars each year in training technicians. As you know, there's a nationwide shortage of qualified techs, and Carter also invests in several community colleges in Maryland, such as Baltimore County P-Tech, Solars Point, Carroll County Career and Tech Center, amongst others, in order to maintain a pipeline of qualified students. Carter also has an accredited 15-month training program with the state of Maryland for apprenticeships for students to help fill the void of techs. Out of an abundance of caution for the public safety and environmental concerns with this legislation, we feel there is no need for a right to repair in the construction industry. Thank you.
Thank you for your testimony, Mr. Lambert. Any questions for Mr. Lambert? Okay, seeing none, we will move on to Tara Ryan.
Good afternoon, Chairman Dumais, members of the committee. Thank you so much for allowing me to be here today. My name is Tara Ryan. I represent the Entertainment Software Association. We represent the companies that publish computer games for PCs, mobile devices, and consoles. All three of the major console makers, Microsoft, Nintendo, and Sony, are ESA members. I'm here today respectfully to oppose House Bill 84. Today, hopefully all of you know that the quality of video games is like never before. Video games cost somewhere from tens of millions to as much as $100 million to bring to market today. It's similar to what blockbuster movies cost to bring to market. Across the United States, video game players span every age, every gender, and every ethnicity. 75% of US households have at least one gamer at home, and the industry has an economic footprint in every one of the United States. In Maryland alone, there are nearly 30 video game publishers, development hardware companies. Many of those, I would say the majority of those, are very small businesses, not big businesses, and I'll get to why that's important in a minute. Unlike many of our products, console makers, unlike many of the products you've heard about, and a lot of digital products, console makers have to not only protect the integrity of their own consoles, but they have to protect the games that are played on their devices, often created, as I said, by other game publishers, both large and small. Under this bill, console manufacturers would be required to share schematics, diagnostic information, tools, security-related codes with unauthorized parties. We believe this mandate is detrimental because of the risk it poses to game publishers and other copyright owners who rely on the secure media environment of the game console to secure their safeguarded works against very sophisticated piracy efforts. You've heard from a variety of speakers before the group that's on the side of opposition that copyright is not impacted by this. That is not accurate. It is very much impacted by this. And it's important, people have talked about the priority is business, the priority should be consumers. Our priority is the security of copyrighted material. That's our number one priority. To prevent content theft, video game software, firmware, and hardware have built-in security features, and they're called technological protection measures. They're also called TPMs. These prevent the play of unauthorized video game content, as well as they prevent access to other protected content that's on the consoles. TPMs do things like run verification checks to ensure that games are legitimate. If the game's legitimate, the console will play the game. If it's not legitimate, the console won't play it. But by granting unauthorized repair shops access to tools and sort of the know-how to modify firmware, it exposes our platforms to potential tampering, including the ability to disable and remove the TPMs that protect this content. And despite some earlier testimony by some of the groups before us, federal copyright law still makes it illegal, not only to infringe copyright, but to traffic in illegal tools that can be used to circumvent consoles, the TPMs that are on consoles, and any state effort requiring these tools be made available to unauthorized repair shops would likely be in conflict with federal law. The US Copyright Office, also the leading authority in copyright issues, just as recently as 2018, recognized that TPMs are necessary and directly related to combating piracy. But despite all of this, there is a thriving hacking and modification market out there that offers services and tools and other ways to modify games and consoles so people can play illegally downloaded games. Our console makers, for that reason, are committed to providing consumers with repairs that are secure, reliable, and affordable. Our companies recognize that consumers want to have their consoles back in their hands as quickly as possible, as inexpensively as possible. All of our console makers have warranties. All of our consoles makers provide services beyond the warranty period. Choice exists. You can take your console down the street to the local shop and you can get a lot of repairs done to it. I'm not sure why you would do that since we have such a great repair record across all of our consoles. And we have, which should make it so that you don't want to do that. You should just be able to send it back. But, excuse me, but now I've totally lost my track of mine. You can send your console back. We have great repair records. I think if you talk to a lot of the proponents of this bill, they would tell you that the video game console manufacturers have a very strong repair record. We believe that marketplace solutions exist and they're preferable to the risks that are created by this repair mandate. The continued enjoyment of playing video games on consoles relies on the continued viability and success of the game console, and that's dependent upon the trustworthy and secure delivery platform. For these reasons, we encourage you to vote against House Bill 84, but we remain ready to work with you as you address these issues. Thank you.
Thank you, Ms. Ryan. Any questions for Ms. Ryan? Thank you very much. Seeing no questions, we will move on to Mel Goldsmith. Mr. Goldsmith still here?
I am. Can you hear me?
Yes.
Okay, thank you. Madam Vice Chair DeMay and members of the House Economics Matters Committee, thank you very much for the opportunity to present to you today on House Bill 84. My name is Mel Goldsmith and I represent Atlantic Tractor as the CEO. We are an agricultural equipment dealership organization with 8 locations in Maryland. We employ a total of 275 employees with approximately 215 of those employees in Maryland. In brief, we oppose the passage of House Bill 84. Our dealership strives to bring our customers value in all we do. To do so, we spend significant capital each and every year to ensure our technicians have the latest tools, equipment, safety, and technology training available. While John Deere equipment has become more sophisticated, Deere supports the customer's right to repair and has built advanced diagnostic capabilities into equipment that are already available to the owner, dealers, or others. And for those customers who require even greater diagnostic capabilities, John Deere provides subscription access to Customer Service Advisor, a specialized diagnostic tool very similar to the one we as dealers use in the field to support our customers. Additionally, end users have access to onboard diagnostic tools via in-cab display or wireless interface, as well as manuals, product guides, mobile apps, and product service information. All of this is available in the marketplace today and has been for several years. Furthermore, U.S. Clean Air Act requires equipment manufacturers to build in-base level tampering safeguards, restricting access to the software that defines the machine's emissions performance is part of these base level tampering safeguards put in place to meet the requirements of the Act. Simply put, providing easy access to the software file for reprogramming or flashing a controller makes it much easier to tamper with the emission systems. Due to these facts, we believe that the proposed language in the bill allowing for third-party access to the software is a direct contradiction of the U.S. Clean Air Act. Acknowledging that the owner has the right to lawfully repair his or her equipment, John Deere recommends against unauthorized modification of the embedded software code. Providing access to the software not only undermines manufacturers' innovation and intellectual property rights, It also creates significant data privacy risk. In addition, unauthorized and illegal tampering, such as changing engine horsepower, speed limits, or defeating emission systems, creates unknown liability issues for the individuals who modified the code, dealers who subsequently traded in that equipment to resale, and/or any subsequent owners of that modified equipment. More importantly, beyond the liability concerns is the risk for potential safety impacts. It is my responsibility as a dealer to ensure that my employees return to their families safely each night. Working on or operating equipment that has been modified, many times in unknown ways, poses a serious threat to the safety of our employees, as well as any customers who may purchase that equipment in the used market. I would like to highlight the fact that an off-road sector coalition has been established because of this very important issue. To our knowledge, it is the largest off-road coalition for any state matter, which signifies the seriousness of the issue. Coalition members represent such sectors as the marine manufacturers and dealers, snowmobiles, portable generators, power tools, remanufactured products, off-highway recreational vehicles, equipment lenders, and major customers organizations such as the National Association of Landscape Professionals. The reason these organizations oppose this legislation is because of the very significant public safety and environmental concerns I have raised in my comments. I believe that your committee has also received a letter of opposition to House Bill 84 from that coalition. Right to repair is a complicated yet important issue. As mentioned, our customers currently have the ability today to lawfully repair their equipment. These solutions were enacted not as a result of a legislative mandate, but rather to fulfill a need in the marketplace. For all of those reasons I have highlighted today, we oppose House Bill 84. I urge an unfavorable report. Thank you very much for your consideration of our opposition against this bill.
Thank you, Mr. Goldsmith. Are there any questions for Mr. Goldsmith? Seeing none, we will thank you, Mr. Goldsmith, for your patience today. We're going to move on to Drake Jamali.
Hi. Afternoon, Vice Chair and members of the committee. Again, my name is Drake Jamali. I'm with the Security Industry Association based in Silver Spring, and we represent companies in the physical and cybersecurity space with over a dozen companies headquartered in Maryland and with employees. And I'll be brief. I submitted my written testimony, so you can, of course, look at that. And I'd first like to start, of course, that, the bill is well-intentioned, but there are a lot of concerns from our industry's point of view. And due to the overly broad definition of digital electronic equipment, our members will have to disclose diagnostic and proprietary reparation information to individuals who do not have the requisite skills to repair such defects, and might put the equipment's integrity at risk for commercial and residential security equipment. And some examples could include cameras, alarm systems, carbon monoxide detectors. An example I'd like to just briefly describe is that if you have a home system device, that prevents someone from entering your home without your authorization, and then there's a defect, and you bring it to a non-authorized repair provider, and they open it up, and they say they fixed it. You bring it back, you install it again, and then someone does break into your home. We see issues with liability concerns. Who's liable? Is it the independent repair provider? Is it the individual? Is it, of course, the original equipment manufacturer? And these are some concerns that we, especially in our industry, feel are crucial to address before we can support any such bill. And of course, the house catching on fire, pipes leaking, carbon monoxide. If a video camera doesn't work and your store during a robbery, these are all, of course, different examples of how authorized repair providers have the requisite skill sets and equipment and know-how, and go through a long and of course effective process of learning how to repair these devices. And just of course, one example in Maryland alone, Panasonic is a good example here. They have dozens of authorized repair providers all over the state. If somebody has an equipment that's having malfunctions, they can take it to them. And also they have the know-how and the authorization to get into the cybersecurity issues that we've also seen. And that kind of goes into the Internet of Things devices that we've heard discussed today. We see that there might be some issues around cybersecurity and also personal information that could be disclosed if it was taken to an unauthorized repair provider. So for these concerns, we oppose HB 84. And happy to take any questions. Thank you.
Thank you, Mr. Jamali. Any questions for Mr. Jamali? Seeing none, we will move on to Robert Dinsmore.
Hello, can you see?
Yes.
Okay. Good afternoon, Madam Vice Chairman and committee members. For the record, my name is Robert Dinsmore, and I'm here to testify in opposition to House Bill 84 because in our industry, the bill is unnecessary and ill-advised. I'm the principal owner of Searsville, New Holland Incorporated, a farm and rural lifestyle equipment dealership located here in Frederick, Maryland. Our company has served our community of customers since 1947, and we employ 16 people in parts, sales, service, and administration. Our business and our industry are built on long-term relationships with our customers. We hold on to those relationships based on the service we provide after the tractor is sold. Uptime on the machines purchased by our grower, producer customers, and professional users is critical to them and to us. To support customer maximum uptime, I can report the leaders in our industry are now making available to customers on fair and reasonable terms and through dealers like me, tools they've asked for to allow them to better control their service requirements and downtime. A purchaser of New Holland equipment can now acquire a subscription to the diagnostic software that my technicians use in our shop. Customers can purchase the same operator's manuals, parts manuals, technical manuals, and technical schematics that my employees use. Customers can purchase how-to videos on a number of service and maintenance topics. And customers that want to do repair have always readily been able to identify, find, and purchase the parts they need when they need them. New Holland calls this our service and repair information customer access. And finally, customers have access to our highly trained and equipped service technicians in our shop or at the customer's location as needed. I also should add that with each generation of new tractor, the onboard diagnostic capability is enhanced, and the operator has significantly greater access to diagnostic and issue correcting information. Likewise, we continue to see vast advancements in our ability to remotely access a customer's tractor to help the customer understand and deal with any issues that may arise. There remain two areas in the bill that are of great concern to the off-road equipment business. First, the requirement that manufacturers provide updates to embedded software. And secondly, the requirement to provide reset capability for security systems. The owner of a piece of equipment has the right to lawfully repair his or her equipment. However, modifying or reverse engineering the embedded software can create a situation where the machine does not meet customer expectations, may exceed acceptable emission levels per the Clean Air Act, or might create an unsafe environment for those operating the vehicle, those bystanders near the vehicle, independent repair providers, or my technicians repairing the vehicle. I can tell you the dealers like us do not have access to the embedded code in our machines and do not modify software on the machine controllers. Second concern is the requirement to provide reset capability for security systems. The most common reason that a tractor goes into limp mode is a failure in the engine. Failures in the engine are more often than not the result of or create a failure of the emission control systems on the tractor. These systems are not unlike the catalytic converter on your car. Knowingly or intentionally ignoring, defeating, or overriding the emission system on a tractor is illegal and is potentially very expensive for the owner. Setting the stage for a potential situation conflicts with existing law and does not make good sense. We believe this bill blurs the line separating repair, which our industry wholeheartedly supports, and modification, particularly in the areas of environmental and safety issues, which we cannot support. For these reasons, we ask that you set aside House Bill 84, particularly for off-road equipment. Thank you for your time and consideration.
Thank you. And again, thank you for staying through the end. Any questions for Mr. Dinsmore? Seeing none, we have one last witness who's actually signed up as information and not necessarily for or against, Mr. Looney.
Thank you, Madam Chair, members of the committee. I just wanted to point out that, and Delegate Fellmark mentioned this, we were working on some language. It wasn't finalized yet.
Mr. Looney, we're having a hard time hearing you. I don't know if you can up your volume.
Okay, let me try this. How's that? Any better?
That is better.
Okay, so I've been working with Delegate Fellmark on some amendments, basically to clarify that leased equipment would not be covered under this. She mentioned the challenges you can imagine if you don't own something and you're just leasing it and you try to fix it and you totally destroy it, creates a very uncomfortable situation. So she and I are going to work on some language, and that should address the concerns of Comcast and anyone else that has leased equipment out there, because right to repair gets, as you can hear, it's a complicated issue to begin with. It gets really complicated when it's with leased equipment. So thank you, Madam Chair.
Thank you very much. Any questions for Mr. Looney? Seeing none, I believe that concludes the hearings for today, and we will be back again tomorrow for further bill hearings. Thank you all for your patience, and look forward to seeing you again tomorrow. And thank everyone for being here for as late as they were. Have a good night.